Can I just check with Zunaid? We have also started, we are now live on YouTube.
While we are waiting, let me just collect my extension so that my battery doesn't die on me.
Maybe proceed, Chief Justice.
He's collecting his extension, Leona.
Chief Justice, are you with us?
Justice Serona, have they all been let in?
Yes, Chief Justice. We are ready to proceed. Yes.
Yes, Ms. Kumalo, over to you.
Good morning.
Oh, I thought it was you. Yes.
Good morning. I am the Register Clerk for this hearing. Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of University of Johannesburg and Auckland Park Theological Seminary and another for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please you, Chief Justice,
Thank you.
Justices of the Court, I appear for the applicant together with my learned friends Mr. Mandel and Ms. Kumalo.
Thank you, Mr. Cockrell.
May it please the court, I appear for the respondents.
Thank you, Mr. Kairinos. Mr. Cockrell, 10 minutes without interruption. And as we indicated, if you could clarify how you and Mr. Mandela are going to divide work between yourselves.
Thank you, Chief Justice. Chief Justice, members of the court, I intend to address three issues in the course of my oral submissions this morning. The first question is whether the Supreme Court of Appeal erred when it found that the evidence regarding the background and the context of the lease was inadmissible. That is largely a legal question, and that's the first question I intend to address. The second question I intend to address is, if the SCA had chosen to have regard to the evidence regarding the background and the context of the agreement, would that evidence have showed that the rights given to ATS under the lease were incapable of being ceded? That is largely a factual question. And then the third question I intend to address is whether the cession by ATS, that's the first respondent, to WAMJ, amounted to a repudiation of the lease, which entitled my client to cancel the lease. Now, Chief Justice, I intend to focus most of my time on the second of those questions. The first question is surprisingly easy to address, or surprisingly brief to address in argument. And the third question also will be relatively short. As I indicated in chambers, Chief Justice, depending on the level of detail we get into regarding the third question, I may ask my learned friend, Mr. Mandel, to address you on parts of the third question. But if the level of detail is, if we don't get into this significant level of detail, then I should be able to address the third question myself. So, Chief Justice, those are the three questions I intend to address. And let me start with the first question, which is this. The SCA said that there was a lot of evidence that had been led regarding the background and the context to the lease. And the SCA said that that evidence was, quote, plainly inadmissible. And therefore, the SCA didn't have regard to any of the evidence. So if you take a step back, Chief Justice, members of the court, and you ask yourself, what did the SCA not have regard to? Well, all the evidence regarding the cooperation agreement, all the evidence regarding the minister's consent, all of that evidence they simply ruled was inadmissible. And so the first question with respect for this court is, was the SCA right in law to rule that the evidence was inadmissible? Now, in our heads of argument, we've distinguished between two rules which the SCA appear to run together in the course of their judgment. The one we call the integration rule, and the other, following Chief Justice Corbett, we call the interpretation rule. But Chief Justice, I've read my learned friends' heads, and they place no emphasis, they place no reliance on what we've called the integration rule. They only rely on the interpretation rule. And so that's the rule I want to address to you this morning. Now, if one simply takes a bird's eye view of the SCA jurisprudence for the past 8 years regarding what evidence is relevant when one interprets a contract, I think the overwhelming impression one gets is that the SCA has eased the restrictions on the admissibility of evidence and has said that the evidence is relevant regarding context and background if it's going to help the court when it comes to interpreting an agreement. As the SCA has said, context is everything. Now, against that loosening of the rules regarding the admissibility of evidence regarding background and context to an agreement, the present judgment of the SCA simply stands out, because in this case, the SCA said that none of that evidence was relevant. So whereas in the past, they've told us that context is everything, with respect to the SCA, in this case, they said that context is nothing. And they simply closed the door on all of the evidence which shed light on the context in which the lease agreement had been concluded. And the question for this court, the first question is, was the SCA right to rule that all of that evidence was simply inadmissible? And with respect, Chief Justice, members of the court, this court has already answered that question and has already held that the SCA's approach is wrong. It has done so by quoting on numerous occasions the judgment in Endomeni, and we give all the authorities in our heads of argument. And Endomeni, of course, accepts that evidence regarding background and context is relevant if it's going to assist in the interpretive task. Now, Chief Justice, of course, we accept the evidence must be relevant. It's not a complete open sesame. But if the evidence is relevant, then with respect, what the judgment in Endomeni indicates is the evidence should be admitted if it's going to assist the court when it comes to the interpretive exercise. And significantly, the respondents accept that this court has previously endorsed Endomeni. Chief Justice, if the SCA were right that in a case of this nature, all evidence regarding background and context is simply inadmissible, I'd like the court please to consider what that means for the doctrine of Delecta's personae, the doctrine that is the centerpiece of this case. In all cases where Delecta's personae is raised, the contract is always silent regarding that issue. The question for a court is always, well, the contract doesn't mention whether the rights are personal to the creditor, but does the doctrine of Delecta's personae nevertheless apply? If the SCA were right, this court and any other court would always have to grapple with that issue with no evidence regarding the background and the context of the agreement. And with respect, it would effectively kill off the doctrine of Delecta's personae. It would have no further role to play. So with respect to the SCA, we say in relation to the first question that the answer they gave, that the evidence was inadmissible, was wrong. Now, Chief Justice, members of the court, we've looked closely at our learned friends' heads of argument on this first question. And let me try and summarize their heads as simply as I can. Our learned friends say, the law is as stated in Endomeni. No dispute about that. They also accept in their heads that evidence of context may be relevant to determine the nature of the right that is being ceded. They accept that. But having made those two concessions, they nevertheless say that the SCA was correct to rule that all of the evidence regarding context and background was inadmissible. But with respect to our learned friends, those three propositions are at war with one another. If the law is as stated in Endomeni, and our learned friends accept that, If evidence is relevant to determine the nature of the right that is being ceded, and our learned friends accept that, then with respect, it must follow that the SCA was wrong to rule that all of the evidence regarding background and context was inadmissible. That is simply a logical consequence of the two concessions made by our learned friends. And so, Chief Justice, members of the court, in relation to the first of the questions, may I summarize our submission? With respect, the SCA was wrong to close the door on all of that evidence and to rule that it was inadmissible. That is not a correct reflection of the law. It's not a correct reflection of the SCA's own jurisprudence. We indicate in our heads that the SCA cited 3 judgments in support of ruling all of the evidence inadmissible. That's in footnote 10 of its judgment. And with respect, none of those judgments provide support for what the SCA did in this case. So in relation to the first question, our respectful submission would be that the SCA was wrong to rule that all of the evidence was inadmissible. And Chief Justice, that then brings me to the second question, which is going to take a bit longer. The second question is this: if the SCA should have had regard to the evidence regarding background and context of the lease, what conclusion should it have reached? And in particular, should it then have concluded that the rights vesting in ATS under the lease were incapable of being ceded? And I'm going to submit that that is the conclusion that they should have reached. That, of course, was the conclusion reached by the High Court and also by the full court. And I'm going to spend some time, if I may, making submissions in support of why the evidence shows that. Chief Justice, in relation to this second question, I'd like to distinguish between some legal issues and some factual issues, if I may. And let me start with the legal issues. Our learned friends very fairly accept that the law is correctly stated in our heads of argument that there are in principle 2 ways in which a right under a contract may become incapable of being ceded. The one way is if you go to the contract and you see a clause saying the rights cannot be ceded. And that's sometimes referred to by the Latin, the pactum Dei non cedendo, an agreement not to cede. That's the one mechanism. But the second mechanism is the one that is of interest to this court today. The second mechanism is where the rights are so personal to the creditor that renders the rights incapable of being ceded. And that second mechanism is referred to in the authorities as Delecta personae, choice of person. Now, Chief Justice, our pleaded case is about the second of those mechanisms, not the first mechanism. And once one draws that distinction between pactum Dei non cedendo, an agreement not to cede, and Delecta personae, choice of creditor, a number of important legal consequences follow. And here we do disagree with our learned friends. So let me indicate what the disagreement is and what our submissions are. The first question that arises is, what is the test for Delecta personae? In other words, what does a court ask itself when deciding whether Delecta personae applies? And we've given you the authorities in our heads of argument, but in brief, the question is, does it make a difference to the debtor, the person owing the obligation? Does it make a difference to that debtor whether the rights vest in person A or in person B?
While you are there, Mr. Cockrell, the 10 minutes has expired.
Thank you, Chief Justice.
Mr. Cockrell, if you could allow me, if we could go back to your first point. You said the law is settled on the interpretation, and if one has regard to endumeni. What I would like to know is if the SCA, as you say, erred, is that because they applied the principle incorrectly? And if so, what is the court's position, this court's position, where the court, that is like the SCA or the other court, applied the principle incorrectly?
Now, with respect, it's not that they applied the
This
law
will affect
incorrectly.
the question of leave.
Yes, no, thank you. I'm grateful for the question. With respect, the SCA got the law wrong. In footnote 10, they cite three judgments as authorities for the proposition that the evidence regarding background and context is inadmissible. One of those judgments, remarkably, is Endomeni itself. But none of those judgments support the conclusion the SCA reached. So with respect, the SCA's understanding of the law in this case was simply wrong. Far from the evidence being inadmissible, it was admissible if it was relevant, and I'm going to indicate that it was indeed relevant. So Justice Matlantla, as you, with respect, quite correctly point out, this is relevant to the leave to appeal issue. This is the point of general public significance, because every day in countless courts around the country, courts are sitting with contracts having to interpret them. And one of the questions they ask themselves is, do I admit evidence regarding background and context? If one reads the SCA judgment in this case in isolation, what it would suggest to a high court is the evidence is inadmissible. And with respect, that is not a correct reflection of the judgments cited by the SCA itself, and it's not a correct reflection of the jurisprudence of this court. So Justice Belantla, we would say with respect, it's not just that the SCA applied the principles to the facts incorrectly. The real concern is that the principle they cited is not a correct reflection of the principles that apply when a court decides whether evidence regarding background and context is admissible or not. And that indeed is one of the grounds, probably the major ground on which our clients, my clients, sought leave to appeal in this case.
Mr. Cockrell, just to follow on the question of my sister, Justice Ntlantla, would that mean, is your submission that the SCA misapplied the law? Are we dealing with a misapplication of the law? In the sense that the law is settled, but the SCA merely misapplied the law, because that would also go to whether or not we have jurisdiction.
Now, with respect, the SCA got the law wrong. The SCA in footnote 10 cited three judgments as authority for the proposition that the evidence was inadmissible. And with respect, those judgments say in one case the exact opposite, that the evidence regarding background and context is admissible. So with respect, Justice Durand, it's not just a question of misapplying the law, it's a question of getting the law wrong. And this is a critical issue for every high court, and indeed every magistrate's court in the country when it grapples with the meaning of a contract. It's one of, with respect to the SCA, and I really do intend no disrespect, it is one of the great anomalies in this case, how the only authority cited in footnote 10 are authorities that do not support the legal principle in the text. And that is why we say with respect that the SCA simply got the law wrong. May I then go back, if I may, to the second question, and I was dealing with some legal questions arising in relation to the doctrine of Delecta's personae.
Mr. Cockrell,
yes.
Excuse me. I need to take you back also to what my two sisters were traversing with you in relation to the judgment of the SCA. If one has a look at that judgment and also the judgments of that court prior, as well as the subsequent judgment in Hugo versus Keston, one would come to a conclusion that in this judgment, if your argument is correct, they did not follow what is said to be the context. But would that not lead to one point, a misapplication of the law? And if it is a misapplication of the law, one would ask oneself whether that point alone would entertain the jurisdiction of this court. And if you were to argue that it cannot be left unchecked because it would cause confusion, and one would say, at first blush, you may be correct, but when you analyze the judgments preceding it and a judgment given subsequent to it, the law seems to be clear and seems to have crystallized along that point. So that's the first hurdle that you have to surmount before we can deal with the other aspects. In other words, if you are not, you don't persuade us on the leave to appeal point, then you would have to fall flat. But I understand your argument. I just want you to delve in detail on those aspects that I've raised with you.
Yes, no, thank you. I'm grateful for the question. Let me take myself out of sequence, if I may. I was going to deal with leave to appeal at the end, but let me respond to your question, Judge Matopa, because with respect, it's a very important question. You'll know that we rely on
Mr.
two
Cockrell,
bases.
sorry to interrupt you, and I'm really sorry about this. Instead of waiting until you address this question, my question really is tied to Justice Matopa's question and my two other colleagues. What is the effect of the fact that this court, as you correctly said, has embraced endumeni, and the way and the correct way in which the SCA has interpreted contracts? What I mean is this: is this court clothed with jurisdiction, seeing that this court has already made its voice known on how contracts should be interpreted?
Thank you again. I'm grateful for the question. May I respond to your question, Justice Tiki, and Justice Matopa's question this way? You'll know from our heads of argument that we rely on two bases for getting our foot in the door. In other words, two bases for jurisdiction in application for leave to appeal. The first is that it is a constitutional matter, and the constitutional matter we rely on is really in the light of this court's judgment in Delecta. Delecta says that when it comes to enforcing contracts, that is a question of the rule of law, precisely because the enforcement of contracts is critical to the rule of law. It's critical to the expectations contracting parties have. And so we would say, with respect, what has now happened because of the SCA's judgment in this case is that one has a jurisprudence that is very difficult for an outsider to understand. The weight of the SCA's authority says have regard to background evidence and context. But if one were just to read this judgment, the UJ judgment in isolation, seems to say that the background and evidence, the background and context evidence is inadmissible. So with respect, we say that does go to the rule of law because it fundamentally undermines the contractual certainty that this court referred to in Delecta. So that's the first basis for jurisdiction with respect. If we bad on that, the second argument is, well, this does raise an arguable point of general public importance. And the point of importance is this. I'm going to try and respond now to Justice Matopa's question. If you were parachuted into this country and you read this judgment in isolation, you would go to paragraph 11 of the SCA judgment, and this is what you will read. The SCA tells us, in deciding the meaning of a contract, the court must have regard to the words used. The words must be construed objectively. And on that basis, they appear to rule that all of the evidence regarding background and context is inadmissible. Why, they say? Because you must interpret the contract objectively, and therefore you bring a curtain down. You don't have regard to the evidence regarding background and context. But with respect, the only authority you will find for that is in footnote 10 of the SCA's judgment, and none of the authorities say that. The one most directly in point, the Novartis case, in fact, engages with that very submission regarding objectivity and says it doesn't exclude the evidence regarding background and context. So the question to me is, well, how does this trigger 1673b(2) of the Constitution? Well, with respect, it triggers it for this reason. If we bad on the constitutional matter, it triggers it because there is now just a fundamental disconnect in the SCA's own jurisprudence. Most of the authorities say the evidence is inadmissible, but my imaginary person who's parachuted in and reads the judgment in isolation will read that as meaning the evidence is inadmissible. And that, with respect, is the general point of public importance, which is triggered under 1673b.
Mr. Cockrell, I don't get the point that you are making about footnote 10 in paragraph 11 of the judgment, which is at page 910 of the record. Footnote 10 relates to the principle that the words must be construed objectively. I'm not sure we can look at that sentence and the cases cited there for support that the SEA is saying we do not look at context. And I'd like to refer you to paragraph 10, where the SEA judgment deals with context. Here, there was nothing in the lease itself that shows that ATS's rights under the lease were not intended to be ceded. UJ sought to meet that difficulty by inducing oral evidence under the guise that such evidence was being introduced as to context, properly construed. However, such evidence was introduced to add to, vary, or contradict the general words of the lease. What the ACA seems to be saying is that the evidence sought to be introduced did not go to context. It doesn't seem that the SCA was saying that context is not relevant.
Justice Ron, thank you. I do understand the question. The difficulty in paragraph 10 is that no authority is cited. So no authority whatsoever is cited by the SCA. The only time any authority is cited is when we come to footnote 10. But if I can just engage with what the SCA said in paragraph 10, Justice Ron, we would at least understand that if the oral evidence that was led was about a pactum de non cadendo. In other words, if the SCA had said, I go to the lease and I don't find an agreement not to cede, and you were now trying to lead evidence to show that there was an agreement not to cede, then we would at least have understood what the SCA was saying. But that wasn't my client's case. My client's case was not about a pactum de non cadendo. It was about the fact that the obligation my client owed to ATS was personal and therefore was incapable of being ceded. Now, with respect, Justice Ron, when the SCA says that evidence my client led was not about context, with respect, of course it was. What else was it about? My client wasn't trying to contradict the wording of the lease. It was putting up evidence to show how it concluded the lease with ATS in order to show that from my client's perspective, it made a difference to it whether the creditor was ATS or anybody else, including WAMJ. And how else, with respect, can a court ever engage with the issue of delectus personae other than to hear evidence regarding background and context? Because the agreement is always silent on that question. So, Justice Ron, if the SCA were right in paragraph 10, that would be the death knell for the doctrine of delectus personae. It would never ever apply. Because the only way for a court to grapple with the issue is to hear the evidence regarding the background. And so, Justice Ron, my short response to your question is we understand what the SCA was saying in paragraph 10. But with respect, the evidence wasn't being led by my client to add to vary, or to contradict the general words of the lease. It wasn't trying to show a pactum de non cadendo. It was trying to show why it made a difference to UJ, whether it owed its obligations to ATS or to someone else. That is the very essence of the doctrine of delectus personae. And if this court then asks, well...
Sorry, Justice Mlanga. Is that a question of law or a question of fact, Mr. Cockrell?
Well, it's both. A finding regarding whether evidence is admissible or inadmissible is partly a question of law, Justice Durong. It's a question of fact to the extent that the evidence must be relevant, and the relevance would depend on the facts. We would accept that. So with respect, in answer to your question, it's both. It's a question of law, what is the ruling regarding admissibility of evidence? And it's a question of fact because the evidence must be relevant, and relevance would turn on what the evidence was showing and how it's going to assist the court.
Mr. Cockrell, in your response to my colleagues, Justices Matopo and Chikri, you strongly pegged the response on somebody being parachuted from outside of the country. But the reality is that when South African courts consider the application of the relevant rule or rules, the courts themselves or lawyers in general will not be people parachuted from elsewhere. So they will immediately be able to say that the Supreme Court of Appeal either applied the rule or rules correctly or incorrectly. So that takes me back to the original question that was asked by Justice Mhlandla right at the beginning, which is, isn't the essence of what you are arguing that the Supreme Court of Appeal erred or misapplied and otherwise established legal principle? And if that be so, why are you here? Because this court has several times said a misapplication of an otherwise well-established legal principle does not engage this court's jurisdiction.
Yes, Justice
If I may,
Malanga, again, I am
Mr.
grateful for the
Cockrell,
question.
Mr. Cockrell, before you reply to my colleague, may I just add this to the spanner? You state in seeking to ground this court's jurisdiction that this court needs to pronounce on the correct approach regarding the relevance of contextual evidence in interpreting a contract. But at paragraph 53 of your heads, you then state that this court has already embraced the Endumene approach. From an arguable point of law issue, what then are you asking this court to pronounce upon?
Well, it's this. When one goes to section 1673B, it talks about an arguable point of law of general public importance. I was asked, is this a question of law or a question of fact? My response is, it's at least in part a question of law. And the question of law is, when does the court bring down the curtain and simply say evidence regarding background and context is inadmissible? That is a question of law before one gets to relevance. When I talked about the person being parachuted in, I was being slightly facetious. Obviously, I accept nobody is simply parachuted in. But the reason why I use that image is the difficulty is for anyone reading this judgment of the SCA and trying to extract the legal principle that guides the ruling that the evidence was inadmissible, there is simply nothing there. All you will find is footnote 10, which doesn't say that. And so with respect, I come back to my submission. The arguable point of law of general public importance is, in a situation of delectus personae, is evidence regarding context admissible or is it inadmissible? The SCA in this judgment appear to say it's always inadmissible. Because if the SCA is right, that evidence will always be out.
Excuse me, Mr. Cockrell, let me just put one question. Why is it that one panel of the SCA interpret the law differently whilst against a body of authorities from that court which interprets it in the way that it has been endorsed by this court? Should that ground jurisdiction in this court?
Precisely because that's the general point of law of, let me get the phrase right, Justice Matopa, it's the arguable point of law of general public importance is that for a person who doesn't read all the SCA judgments, a person reading this judgment will be inclined to form the view that evidence regarding context is inadmissible, and that's exactly wrong.
But you would know that one swallow does not make summer. If you see one swallow flying, we can't just say summer is upon us. One wrong by the SCA judgment against the other SCA judgment doesn't mean that we now have summer upon us.
Yes, no, I would accept the metaphor, Justice Matopa. Justice Matopa, I'm going to go back to what I said earlier. Every day, in countless courts around this country, courts are grappling with how does one interpret a contract. If one takes a bird's eye view of the past 8 years of jurisprudence, broadly the trend has been to letting in the evidence. With respect, this judgment goes in a contrary direction. And so we say again, the difficulty is the disconnect between this judgment and the other judgments of the SCA, the difference between this swallow and the other swallows that you refer to, Justice Matopa. And that creates the difficulty for lower courts in the country, unfortunately.
Can I just say this? What would interest me most, if ever you are to argue that we have to look at whether we have jurisdiction or not, is a point that you were just about to embark upon on the Delectus personae, whether it's a question of law or it's a question of fact, and your answer was it's both, right?
Yeah.
And for one to determine whether there is a Delectus personae, you cannot do that without having regard or records to the facts. So your argument would be that as it was the UJ's case, you could not determine it in isolation from the factual metrics. Is that what you are suggesting?
That's exactly the submission.
And that you would say to us would engage our jurisdiction, because if we are to shut that door, the concept or the principle of delectus personae would to excuse the phrase, would be a death knell.
It would be the end of it. There would be no such doctrine anymore, because you will never find in any contract an express provision dealing with delectus personae. That would be the end of the doctrine, Justice Matopa. And with respect, you're entirely correct. May I respond to your question this way? And which is perhaps one way to test it is this. We know that the doctrine of delectus personae is a principle of law. And the SCA tells us in this judgment, they say it follows from the principle that a debtor can't be prejudiced by the session. That's the basis, one of the bases, that's the basis the SCA gives. Now, what did the SCA do in this case? In effect, they held that I'm going to rule on this question without having regard to the background evidence and the evidence of context, even though some of that evidence showed that UJ would be prejudiced by the session. That's what the evidence was showing. The evidence was designed to show that when the right is uncoupled from the duty, it creates a prejudice for UJ. It can no longer look to ATS to build the facility, the higher education facility. That's what the evidence was showing. And so one of the other oddities about the SCA judgment with respect to them is, if the principle of delectus personae rests on prejudice to the debtor, how can it ever be correct to say, I won't hear any evidence regarding the prejudice to the debtor? But that is the consequence of this judgment. If this judgment is correct in any future case, you can't lead evidence regarding background and context if you rely on delectus personae. Well,
Perhaps,
wipe out the doctrine.
sorry. Sorry to interrupt you. Perhaps what the SCA, look, I admit that this judgment is very short and terse, and it is difficult to really understand where the SCA was coming from. But when I looked at paragraph 10 and in page 910,
Yes.
I thought that perhaps what the SCA was saying was that they are rejecting the contextual evidence because it tended to add or vary or contradict the general words of the lease. Mm-hmm. And I thought perhaps that's the reason why they rejected the contextual evidence, because that's what the SCA says. It says that properly construed, that evidence was introduced to have that effect. Yes. I'm not sure that they were correct, and you've covered that in the heads. And I thought that perhaps they were rejecting the contextual evidence because they were of the view that it added or contradicted the terms of the lease.
Thank you, Justice Chiki. Justice Chiki, I sought to address this earlier, but it's such an important question. Let me address it again. If my client sought to lead evidence about a pactum de non cadendo, we could at least have understood paragraph 10. It would then have said, there's no agreement not to cede, but you sought to lead evidence to establish that there was an agreement not to cede. We would then have understood paragraph 10. But that wasn't what the evidence was about. The evidence was designed to show that it made a difference to UJ, whether it owed its obligation to ATS or to someone else, such as WAMJ. That's what it was designed to show. So when the SEA said the evidence was designed to add to, vary, or contradict the general words of the lease, with respect, that is simply wrong. That isn't the purpose of the evidence. That was not the purpose.
So the basis on which they rejected the evidence was also wrong.
Well, they jump between the integration rule and the interpretation rule. Those are the terms we've used in our heads. They jump between the two. It's not easy to work out which one they're dealing with. In as much as it's the integration rule, with respect, the SEA was clearly wrong. In as much as it's the interpretation rule, which is what footnote 10 appears to say, with respect, they were also wrong. And so we come back to Justice Matopo's question to me, and I'm going to ask Chief Justice if I can move on to address that. I understand the importance of the debate about whether we get our foot in the door, whether we get leave to appeal at all. But perhaps I can seek to address that by advancing my own argument, take it a little bit further, and then I will come back to the application for leave to appeal at the end. And Chief Justice, I'm sorry, I think I'm probably about to run out of time already, but I am going to ask you for a slight indulgence, if I may, just to address some of the issues that I haven't had a chance to address.
Yes, carry on, Mr. Cochrane.
Thank you, Chief Justice. So let me go back then to Delecta's persona. I was going to make some legal submissions regarding that, and let me carry on with them. So what is the test for Delecta's persona? Well, it's not the test for a pactum de non cadendo. You don't ask, was there an agreement between the parties? The question you ask yourself is, does it make a difference to the debtor whether its obligation is owed to this creditor or to another creditor? And those are the authorities we've given in our heads. I don't understand there to be any real debate about that.
And would it have made any difference to UJ if MJ were to establish a higher education institution on the land?
Well, it can't. That's the problem, Justice Madlanga. It can't do that because it's not involved in the provision of higher education. That's the fundamental difficulty.
No. Assuming that it was actually a provider of higher education and that when was to establish a higher education institution, would there be a problem? Would there be any cause for complaint? And if so, what would it be?
Yes. No, sorry, I'm grateful for the question. The question you ask yourself at the outset is, at the time when this agreement was concluded, did it make a difference to UJ whether its obligation to grant occupation of the property was given to ATS or to someone else? So let me take a silly example, Justice Malanga. If my client had simply placed an advert in the newspaper offering to lease premises, perhaps residential premises to students, perhaps it wouldn't have made a difference who it leases the property to. But here it made a critical difference to my client who it leased the property to, who it owed the obligation to. Because the whole story that my client put up was there was an association between it and ATS. ATS didn't respond to an advert in the newspaper. ATS was providing a joint agree along with my client. ATS said it needed some additional capacity, some additional space. My client says, in its term, it wanted to lend a helping hand to ATS. On that basis, it engages with ATS, it gets the minister's permission. If you ask yourself, did it make a difference to my client whether it owed its obligation to ATS or to someone else? The answer is yes. That's the whole purpose of the evidence. And so in response to your question, Justice Malanga, it wouldn't, Delecta's persona doesn't mean you can cede your rights to someone else as long as they also provide higher education. Delecta's persona means it makes a difference to you, the debtor, who you owe your obligation to. And once that's the case, the rights can't be ceded, even if it's to someone else who is providing higher education. So the short answer to your question is, if it made a difference to you, Jay, the rights were incapable of being ceded, no matter who they were ceded.
Yeah, I'm asking because, as I understand it, part of the substantiation onto why we say, that is, UJ says, choice of this person, there is also a lot of emphasis on the fact that WMJ is going to provide education at a much basic, or let me use the terrible word, lower level, as opposed to higher education.
Yeah.
So I'm saying Wits, which is not too far away from the main UJ campus, says we are going to use this, and let's establish from you ATS. Because as I say, or at least as I understand, there is a lot of focus even on the fact that what's being provided here is not the sort of education that was be provided.
And with respect, you're entirely correct, Justice Malanga. What I would add to that, though, is the relevance of that evidence was to show why it made a difference to UJ, whether it owed its obligation to ATS as opposed to someone else. Let me use a hypothetical example. Sometimes these are dangerous, but I hope this one won't be. Assume my client UJ had a vacant plot of ground and wanted to open a petrol station. And assume it simply places an advert or a tender. It may not matter very much to my client whether the tenant is BP or Shell or Engen. It simply doesn't matter in my hypothetical example. But here it does make a difference to my client, because the whole point of the evidence they put up was to show I was not just leasing the premises to anyone who wanted it. The purpose was to couple my obligations to ATS because we were providing joint degrees. And with respect, it's hard to think of a clearer example of Delecta's persona than this. Delecta's persona asks, does it make a difference to you who your creditor is? In my example of BP and Engen, perhaps it doesn't. If I have a vacant flat and I place an advert in the paper to lease it, perhaps it doesn't matter to me, quite frankly, who the tenant is. But here, it made a critical difference to UJ because they wanted to lend the helping hand they spoke of to ATS. And that's what triggered the principle of Delecta's persona. That's why the rights were incapable of being ceded. And I do accept the force of your question, Justice Malanga. That would apply even if WAMJ were providing higher education. Delecta's persona would still prohibit the session.
Mr. Cockrell,
Mr. Cockrell, proceed, Justice Nhlanhla.
what was the role of the cooperation agreement in the conclusion of the lease agreement? And what happened when the cooperation agreement was cancelled in 2007 between the parties?
So the cooperation agreement provided the basis for the lease. When I say basis, it's what gave rise to the lease, and the correspondence shows this. Our learned friends are dismissive about the evidence, but the correspondence shows ATS itself is referring to the cooperation agreement. And so what it shows, Justice Nhlanhla, is when you ask yourself, Delecta's persona, the question, did it make a difference to my client who the creditor was? The answer is yes, it made a difference. Why did they engage in negotiations with ATS? It was because of the cooperation agreement. They were both providing courses leading to certain degrees. So students could do some of the courses with ATS and could do some with UJ. So that's the relevance of the cooperation agreement. It showed why it made such a difference to UJ, who it was leasing the property to. And with respect, you're quite right. The cooperation agreement was in due course terminated. It was terminated because UJ stopped offering the degrees in theology that had been the joint degrees. But that has no impact on the question that one asks at the commencement of the contract, was this Delecta's persona or not? It was. And that doesn't become a different answer because the cooperation agreement is in due course terminated.
What the respondent is saying about the cooperation agreement, though, is that two of your witnesses said that when they were concluding or negotiating the lease agreement, they did not consider the cooperation agreement. What is the impact of that evidence on that?
And they're correct. I went and checked the transcript. They are entirely correct. The one witness said he hadn't read it, and the other one said, as I recall, he read it in the preparation for trial. But it doesn't matter because they were just the arms and the legs giving effect to the decision of the university. They were just the functionaries, if I can put it that way. And they can't talk for the decision of the university. And what we know is that ATS itself refers to the cooperation agreement as giving rise to their approach. Justice Chiki, can I give you the reference? I don't have time to go to it, but can I just give you the reference to the letter which makes that point? If you'll just Bear with me. Yes, it's volume 6, page 539. Volume 6, page 539. That's the letter from ATS to, it was then Rao, it's now UJ. That letter does refer to a sale, Justice Cheeky, but that's because at that stage, UJ was contemplating a sale. It later became a lease. But with respect, it makes it clear that ATS itself regarded the cooperation agreement as forming the basis of its negotiations with UJ. So let me just summarize, if I can, because it's such an important point. UJ and ATS are both providing various courses leading to the degrees. That's the point of the cooperation. That's why my client says, I want to extend a helping hand to ATS. I want to give them the facilities that they need. So the fact that the two witnesses who were responsible for in one case for the drafting of the lease, that's Professor Du Plessis, and in the other case for some of the negotiations, that's Mr. Labuskakin, the fact that they didn't rely on the cooperation agreement is with respect of no relevance.
Speaking for myself, I thought that chapter 2 that deals with the teaching programs actually reflects the symbiosis that was anticipated by the parties when they entered into this kind of agreement. Because you can see there that in fact the intention was that UJ would be the one responsible for conferring the degrees in theology for students registered with ATS. I'm just saying that I thought that the cooperation agreement was also relevant for that purpose.
It was relevant because it explains why these two parties came together. Justice Cheeky, I'll go back to my earlier example. If my client had placed an advert in the newspaper saying, I want to lease the property, perhaps we wouldn't be having this debate about Delecta's persona, but that's not what happened. What brought ATS and UJ together for the lease? What brought them together was the cooperation agreement. So the way I understand it is students would have to do certain modules. Some were only offered by UJ, some could be offered by UTS. So a student would graduate at the end having done some modules with ATS and having done some modules with UJ. So it was a genuine cooperation agreement in the provision of higher education. That's what.
No, my last comment was actually saying that I see the relevance of the cooperation agreement.
Thank you. I'm
not against you, Mr. Cockrell.
Thank you.
Mr. Cockrell, I would like you to address me on the termination of this cooperation agreement. What remains once it's terminated in 2007?
Well, it's gone, Justice Belantla. So I'm going to give you the reference to the record, if I may. I can't find it. There's a letter from Professor van der Merwe, who was then the rector, where he terminates the cooperation agreement. And the letter makes it clear the reason for that is that UJ was no longer offering the degree that had formerly been the joint degree. So at that stage, the cooperation agreement ends. But it doesn't cast a shadow backwards on the question whether at the commencement of the lease, Delecta's persona applied or not. In other words, it doesn't rewrite the history that already existed at that stage.
Mr. Cockrell,
yes.
Mr. Cockrell, in determining the delectus personae, is it necessary to look to the obligation of the debtor in relation to the right?
I'm sorry, Justice Kampepe, I'm just lagging behind you. I apologize. Is it necessary to look to the
in determining delectus personae,
yes.
Is it necessary to look to the obligation of the debtor in relation to the right?
Yes, yes. No, with respect, that's exactly it. So what, Justice Kampepe, one can ask the question in two ways when it comes to delectus persona. One can ask from the perspective of the creditor, the person who has the right, does it make a difference?
Yes.
Or one can ask from the perspective of the person owing the obligation, does it make a difference? And the authorities we've given show that with respect, the right phrasing of the question is, Does it make a difference from the perspective of the person owing the obligation? And we know that because we told Delecta's persona is part of the principle that the person owing the obligation cannot be prejudiced. And once that is so, the right perspective in our submission is to look at it from the perspective of the person owing the obligation rather than from the person owing the right. So the question which the authorities established is this: you ask yourself, from the perspective of the person who assumed the obligation, does it make a difference whether he or she owes the obligation to this particular creditor or to someone else? If it does make a difference, that is Delecta's persona. And if you strip away all the complexity and all the thousands of pages of evidence that the SCA complained about in this case, that's what the evidence was showing. Why did it make a difference to UJ whether it owed its obligation to ATS or to someone else? It made a difference because they were brought together by the cooperation agreement. They wanted to extend the helping hand to ATS. And that's why, with respect, the rights were personal to ATS, precisely because it made a difference to UJ, the person owing the obligation. Chief Justice, I've jumped around a little bit, but I have made most of my submissions regarding the second question. I just need to make brief submissions, if I may, regarding something we haven't touched on, and I thought this was possibly where Justice Kampepe was going in her question to me. It's clause 8.1 of the, it's clause 8.1, which you'll find in volume 1 at page 46. And this is also relevant to Justice Matopo's question to me, which was about the application for leave to appeal. It's about the prejudice to my client, the debtor. 8.1 says, I'm going to translate it, the leased premises self-gebruik will be used by ATS for educational, religious and related purposes. Die oprigting van campus vir onderwys, onderrig, navorsing, opleiding, kantore en studentfacilitator. Chief Justice, there are two things to note about that clause. The one is it's imposing a positive obligation on the tenant to erect those facilities. Self-gebruik word, so will be used to erect the campus. And the second point to note is one that we make in our heads, but I need to give you some authority for that. We say that in Afrikaans, where reference is made to a campus and to student, that is referring to higher education, not to primary or secondary education. I'm going to give you the authorities for that, if I may, because we didn't give them in our heads. And it's such an important point. It relates to the meaning of those terms in Afrikaans. You'll find that in the judgment of the High Court. Just bear with me, please. Yes, you'll find that in the judgment of the High Court, volume 9, page 852, which quotes the authorities, the Afrikaans dictionaries my client relied on. And you'll also find the authorities in our founding affidavit in the application for leave to appeal. It's volume 10, page 958, paragraphs 114 to 115. And so the submission of my client is what clause 8.1 was doing was imposing a positive obligation on ATS to erect the campus, which was a campus for higher education. Now, what happens when the rights are ceded to WAMJ? Well, here's the difficulty. It's correct that the obligation remains in ATS, but it can no longer discharge that obligation because it doesn't have possession of the property. I'll say it again. ATS keeps telling us, and the heads of argument keep saying, but ATS still has the obligation, so what's your complaint? And that's correct as a matter of law, but here's the complaint. ATS can no longer comply with clause 8.1 because it can only comply with 8.1 if it has possession of the property, and it doesn't have. Remember, ATS provides higher education. WAMJ doesn't provide higher education. So WAMJ can't comply with 8.1 because it's not in the game of higher education. Only ATS can, but it doesn't have possession of the property.
What would have been the position, Mr. Cockrell? What would have been the position if WAMJ was also providing higher or tertiary education?
It would have led to a different debate regarding repudiation, Justice Kampepe. It's the third question, which I'm still coming to, but I'll be very brief on it. So remember, our case for repudiation, let me jump ahead. The case for repudiation is by ceding the rights to WAMJ, ATS repudiated. Why? Because it had disabled itself from complying with 8.1, and WAMJ couldn't comply with 8.1 because WAMJ doesn't provide higher education. We accept, Justice Kampepe, if WAMJ did provide higher education, the debate regarding repudiation may well have been different. But because WAMJ doesn't provide higher education, that's what gives rise to the complaint of repudiation. My client says, but you've disabled yourself, ATS. You've purported to cede the rights to ATS, to WAMJ. WAMJ can't comply with 8.1 because it's not in the higher education game. And you can't comply because you no longer have possession. That's the argument for repudiation. And that argument would have been different, Justice Kampepe, if WAMJ had provided higher education. And so, Chief Justice, let me see if I can draw the threads together. I'm sorry, the point I've just made regarding 8.1 is relevant to this issue. It's also relevant to the question Justice Matopo asked me. Well, what is the basis for the principle of delectus personae, and why do we say it was misapplied here when the SCA said I won't have regard to the evidence? Delectus personae, we're told by the SCA itself, is triggered at least in part where the person owing the obligation, UJ in my case, is prejudiced by the session. Well, what did the evidence show? The evidence showed why UJ was prejudiced by this session. The evidence showed it looked to ATS to comply with point 8.1, and when the session happened, it could no longer look to ATS. If you now ask, was the evidence relevant? Well, with respect, of course it was relevant.
Mr.
If
Cockrell,
nothing else, it was showing why there was prejudice.
Mr. Cockrell, can I ask something in line with 8.1? Whether it could have been or it could be possible, assuming you are successful in putting your foot at the door in terms of jurisdiction, but you are shaky on the delectus personae, but you're stronger on 8.1. Would you be successful?
Justice Matopo, I'm sure I'm being slow, but if you'll just run the permutations by me again, I'm trying to work out which parts are good for me and which parts are bad for me in the question.
Well, I'm saying if on jurisdiction you home and dry, then put it that way.
Yeah.
But on the second point that you're arguing on the delectus personae, and you are on shaky ground, but on this clause 8.1, and you are successful, would you still be successful before us?
Yeah, no, then my client would win, Justice Matopo. Sorry, I've caught up with you. Yes, then my client would win. So the logic of my client's argument goes like this. The SCA said, I'm not going to have regard to the evidence. We say, but the evidence was relevant. If for nothing else, it was relevant because it showed why my client was prejudiced by the session. And if it was prejudiced by...
Perhaps let me put it this way. Disregarding what the SCA said about your client's right to lead that evidence on the context.
Yeah.
But you are able to show that insofar as clause 8.1 is concerned, vis-a-vis the obligations of AJ to your client, there has been a breach. Let me put it that way.
Yeah.
And you say, if I fail on these ones, but on clause 8.1, I have made up a case that there has been a contravention or a breach.
Then
would
Then
you
my
be
client
successful?
wins. Yes, then my client wins. Then my client has shown the repudiation that they pleaded in the particulars of claim. They pleaded a number of repudiations, but Justice Matopa, the one you put to me is one of them. The case for repudiation goes like this. UATS purported to cede rights, but that rendered UATS incapable of complying with clause 8.1, because only you could do that. And that was the repudiation that entitled me, UJ, to cancel the agreement, which is what I did. So Justice Matopa, in the question you put to me, that would be good enough for my client to succeed on appeal, yes. It would have come home on the repudiation. And so, Chief Justice, if I can try and draw the threads together then on the three questions. I've jumped around a little bit, but I think I've covered all of them. And let me just summarize, because I wouldn't want to miss anything. First question, was the SCA right to exclude the evidence? We say no. The SCA was wrong. Second question, if the evidence had been admitted, what would it have showed? Well, it would have showed that it made a difference to my client, whether its obligations were owed to ATS or to someone else. That's Delecta persona. It also is relevant because it shows why the effect of the purported cession was to render ATS incapable of complying with 8.1, which is a repudiation. And that then brings us to the repudiation question, the third one, which I said I would address quickly. And you know my argument. Repudiation is when a party indicates an intention no longer to be bound by the contract. What did ATS do here? By purporting to cede, they disabled themselves from complying with 8.1. That was the repudiation that justified my client in cancelling. And that would justify the relief that my client had asked for and which it obtained before the High Court. That's the short answer to Justice Matopa's question. Chief Justice, I want to just quickly mop up on the jurisdictional issue, leave to appeal. I think these points have been covered in my debate with the various justices, but they're such important points. Let me see if I can now express my submissions more coherently in the light of the debate we've had. Is it a constitutional matter? Well, we say it is, and we rely on the recent judgment of this court in Delecta. This court says that the application of the common law rules of contract should result in reasonably predictable outcomes. I'm quoting, enabling individuals to enter into contractual relationships with the belief that they will be able to approach a court to enforce their bargain. The rule of law means that enforcement of contractual terms should not be dependent on the idiosyncratic inferences of a few judicial minds. That's a quote. I go back to my person parachuted in, my slightly silly example. The person parachuted in would say, well, whether the evidence is admissible or not does appear to depend on the, quote, idiosyncratic preferences of a few judicial minds. Sometimes it's in and other times it's not. With respect, that is a question, that is a constitutional matter. But if I'm bad on that, I then rely on section 1673b Roman 2 of the Constitution. I say the relevant points of law include what extent the parties, I'm sorry, Justice.
Mr. Cochrane, I'm sorry, before you move to the second, does it mean then that the enforcement of all contracts raises a constitutional issue? If not, what kind of enforcement raises a constitutional issue?
Yes, and Justice Jafta, we would say, sorry, again, I appreciate the question. We would say it's a constitutional matter here because every time anybody interprets a contract, any court interprets a contract, the first question they have to ask themselves is, do I hear evidence or not? Where different courts are taking different approaches regarding the admissibility of that evidence, that goes to the Delecta issue. With respect to the question you asked me, does it mean every time I enforce a garden variety contract it's a constitutional matter? The answer is probably not. But in a fundamental question like this, is the evidence admissible or not as a matter of law? That goes to the issues that were flagged by this court in Delecta.
But how do we peg it on the admissibility of evidence, or rather on the enforcement of a contract, rather than the issue of admitting evidence that relates to the interpretation of the contract? That's why I'm getting difficulty, that why do we say it's an enforcement of a contract that raises a constitutional issue rather than, you know, the or receipt of evidence which is relevant in determining actually what the parties meant, which would be relevant to your second leg, not the constitutional issue.
Because the admissibility of the evidence determines the meaning of the contract, and the meaning of the contract determines the enforcement. So if we take a step back, the anterior question is, what are the rules determining whether the evidence is admissible or not? And that is the question triggering the Biediger issues in our submission.
No, I accept that, but my problem is, how does it become a constitutional issue rather than an arguable point of law of general public importance, which is another leg that you're relying on?
Yes, I'm with you. No, in the same way as the rule of law was held to be a constitutional issue in Biediger. That's the only answer I can give Justice Chapter. So this argument is squarely based on Biediger. It stands or falls on what this court said in Biediger.
I may be wrong. My recollection of Biediger was, it was more of upholding the principle of, is it pacta sunt servanda? Yeah. Which the court said that principle also advances the value of freedom, and therefore, if you are upholding it may raise a constitutional issue. Or am I wrong?
No, with respect, you aren't wrong, Justice Chapter. What this court said in Biediger is pacta sunt servanda gives rise to rule of law issues, because when you conclude a contract, you should be able to arrange your affairs secure in the expectation that the courts will lend their muscle when it comes to enforcement. That's the rule of law issue. And with respect, we say it's a step from there to our case, but it's a permissible step to say the same issues arise where a party comes to court to enforce the contract, pacta sunt servanda, and the debate relates to, how do I determine the meaning of the contract that is going to be enforced? In other words, what are the legal rules determining how I determine the contract that I have to enforce a la Biediger?
And in Biediger, the context was that the enforcement of that term of the contract was against public policy. So the whole issue was informed by determining whether upholding that principle of the common law is against public policy. So that's why I'm battling to understand how a constitutional issue arises.
Dr. Chapter, I say this with respect, obviously your reading of Biediger is correct. We say when you take a step from there, the step is a permissible one, but we do accept it's a step. But if I'm bad on that, Justice Chapter, then 1673B1 of the Constitution applies. And this is the debate we've already had, but let me try and summarize it. We would understand the concerns of this court if the only question related to whether the SCA had correctly applied the Endomeni principle to the facts. We would then understand the misgivings of this court. But that's not why we come before you. We come before you and say, when you read the judgment of the SCA, it appears to create a different rule regarding the admissibility of the evidence. It appears to say, we've had the debate whether it does or doesn't say it, but it appears to say that in this case, the evidence is inadmissible. And if that's the case, then with respect, we say the arguable point of general public importance relates to the circumstances in which evidence is admissible when it comes to interpreting a contract. And more particularly, this is my response to Justice Matopa's earlier question, when is evidence admissible to establish Delecta's persona? Because on the most restrictive reading of this SCA judgment, it's the end of Delecta's persona. You can cross it out of the textbook, you can Tipex it out, it's gone. Because if the judgment is correct, you can never lead evidence regarding background and context And when you read the contract, it'll never tell you anything about Delecta's persona. That's the whole point. So the only way to establish Delecta's persona is to have regard to the evidence of background and purpose. If you can't lead that evidence, the doctrine simply dies a death. And so with the greatest of respect, we do say the SCA was wrong in this case. And the wrongness doesn't just impact on my client, the wrongness impacts on anyone who intends to rely on Delecta's persona going forward. And that then gives rise to the arguable point of general public importance. And Justice Matopa, I hope that's a response to the question that you asked me right at the beginning of my address, and I said I would come back to it. Chief Justice, I've then covered all of the topics I wanted to cover. I have gone a little bit over time, and I'm grateful for the indulgence. You'll know that my client asked for leave to appeal, and if leave to appeal is granted, it asks that the appeal succeed. It also asks for the cost of due counsel. May I just have 1 minute, Chief Justice? I'm in Cape Town. The rest of my team is in Johannesburg. If I can just check if they've sent me any messages to say whether I've missed something, please.
Thank you.
No. Chief Justice, those are our submissions. Thank you.
Thank you, Mr. Cockrell. Mr. Gairenos.
May it please the court. If I may begin with the question which I believe Justice Madlanga asked my learned friend, which was, in essence, should we be here? And this, of course, relates to whether this court should grant leave to appeal, which in turn relates to the issue of whether this court should exercise its appellate jurisdiction over the Supreme Court of Appeal. Now, we know that although the founding papers of the applicant raised a constitutional point, they appear wisely to have abandoned the constitutional point which they raised in the founding papers. And we submit they no doubt did so because of the ratio in the decision of Phillips versus Director of Public Prosecutions, which we referred to in our answering affidavit, and which unfortunately one doesn't find in the heads of argument, but no doubt because we believed that the applicant had abandoned the constitutional point. And of course, what this court said in Phillips is that you cannot raise a constitutional point on appeal to the court. It has to be raised in the court of quo. It has to be raised in the pleading so that it may be properly dealt with in the lower courts. And of course, that didn't happen in this matter. So I'm going to argue from the premise that the constitutional point which was raised in the founding papers has been abandoned. Now, the next point which the applicants rely on for suggesting that this court should exercise its appellate jurisdiction over this matter is the one that my learned friend has just addressed with the court. And that is that he says with a reference to the judgment in Bodica that, well, if there aren't predictable outcomes by a court such as the Supreme Court of Appeal, that per se raises a constitutional issue or a constitutional matter within the meaning of section 1673B Roman 1 of the Constitution. But we submit in that regard that if one applied that test, and every time the Supreme Court of Appeal perhaps misapplied the law or got it wrong, if a party could on that basis alone, because there isn't a predictable outcome, and one is left with the individual idiosyncrasies of a particular bench in the Supreme Court of Appeal, if that allowed a party and allowed this court to exercise its appellate jurisdiction, it would, with respect, open the floodgates, because every single party could then conceivably argue, well, the Supreme Court of Appeal got it wrong, they misapplied the law, and on that basis alone, it raises a constitutional matter as defined by my learned friends, because there isn't a predictable outcome, and therefore we should be able to approach the Constitutional Court. And with respect, that's not my understanding of the appellate jurisdiction of this court. The second leg upon which the applicants rely is the reliance on an issue of public importance. And that's where they come in and they say, well, the Supreme Court of Appeal misapplied endumeni or has created a new body of law in relation to what type of evidence may be considered when determining whether a right or the obligation is delectus personae. And they got it wrong, and therefore this court should exercise its appellate jurisdiction. Now, in that regard, we raise two issues. One, the court didn't change endumeni. It didn't refuse to apply endumeni. If anything, having regard to the judgment, it sought, in fact, to apply the principles in endumeni. There does not appear to be any inconsistency between the various decisions in the Supreme Court of Appeal in relation to endumeni. The Supreme Court of Appeal, as this court, has very strongly embraced the principles of interpretation of contract as set out in endumeni. And perhaps the problem that has arisen, we submit, in what the Supreme Court of Appeal did in this matter and how it applied endumeni arises perhaps from a confusion about what the case was actually about. And that confusion potentially arises from the manner in which the case was pleaded. So what we are submitting is that if one has regard to the context, and excuse the pun, but the context of the matter as far as the pleadings are concerned, if one looks at the judgment in the context of the pleadings, one starts to realize why the Supreme Court of Appeal found on the facts of the matter and as pleaded in the pleadings that they would not allow contextual evidence of surrounding circumstances in order to ascertain whether the right was delectus personae or not. And if I may just take the court very quickly to the pleadings, you find it at volume 1, and this debate will also inform in due course my argument in relation to the concept of delectus personae and whether the court was correct on the merits of the matter in finding that there was no delectus personae in this matter. If one turns to volume 1, which contains the pleadings, and one turns specifically to page 10, at paragraph 12, we see that the entire case of the applicant on the pleadings concerning delectus personae was encompassed really in paragraph 12. Now, preceding paragraph 12, they pleaded a lot of the facts which they relied upon in order to try and establish delectus personae. But then they said, on a proper interpretation of the lease agreement, the rights and obligations created by the lease agreement were personal to the defendant. And perhaps the confusion arises because what they should have with respect pleaded is that on a proper consideration of the facts and circumstances of the matter, and particularly the prejudice caused to UJ, it was clear that the nature of the right or the nature of the obligations were personal to the defendant. In other words, that the right was delectus personae to the first respondent. So what the court then was grappling with was the concept of, you are telling me now to interpret the agreement, and by interpreting the agreement to find that on a proper interpretation of the agreement, the right is delectus personae. Yet when one applies endumeni, endumeni tells us that the starting point always of contractual interpretation is the words themselves, as encompassed in the written agreement, in their proper context. And we have no quibble, as we've set out in our heads of argument, with that contention, that application of the law. But one must not lose sight of the fact that you are starting out by considering the words in the contract in their proper context. And the difficulty, of course, faced by the Supreme Court of Appeal was that there simply were no words in the contract itself which were capable even of being interpreted in any manner whatsoever to raise a delectus personae. And so on our interpretation of the judgment of the Supreme Court of Appeal, effectively what they were saying is, well, in order to determine delectus personae, it's not a question of interpreting the words, because there are no words in this contract that could conceivably be interpreted as meaning that the parties had agreed that the right was delectus personae. And one must bear in mind that when making this determination of delectus personae, it is not about what the parties agreed. The parties' intention is in fact entirely irrelevant. One looks at the nature of the right and, of course, the concomitant nature of the obligation, and one tests whether the debtor is in any way going to be prejudiced by the cession of that right to another party, whereby the debtor is going to have to fulfill its obligations in a more onerous manner. Now, that may, of course, be informed by evidence. Of course, one would have to hear evidence of how the cession would prejudice the debtor, but it's not an issue of contractual interpretation, because that issue is not determined by the contract. Once one has established, if there is, let me just add this, if there is a smidgen of contractual interpretation necessary, it is merely to ascertain the nature of the right in issue. And it appears to me to be common cause between the parties in this matter that the right in issue is nothing more than the right to beneficial occupation. That's the only obligation which UJ had towards the first respondent, was to provide beneficial occupation. There were no other obligations. So then, of course, what this court would have to do is determine in due course when we get there to discuss the delectus personae, and if we get there, if the applicant manages to persuade this court that leave to appeal should be granted, and that there is in fact an issue which this court should exercise its appellate jurisdiction over. Once we get there, we will then determine whether the evidence that was before the court and whether any such evidence was even necessary to establish that the obligation cast on UJ was in fact not more onerous as a result of the session, but I will get to that in due course. So in brief, in relation to whether this court should grant leave to appeal, we submit that there is in fact no issue of general public importance which should allow this court to entertain appellate jurisdiction over this matter. Even assuming that the Supreme Court of Appeal got it wrong, it only would have done so in relation to how it applied endumeni, a misapplication of the principles of endumeni, and that would only be in relation to allowing, whether it should have allowed evidence to allow UJ to try and establish that by the session, its obligation has now become more onerous and therefore it is prejudiced. But to that extent only. But the mere fact that the SCA may have misapplied the principles of endumeni to delectus personae does not mean that this court should exercise appellate jurisdiction, because it is not as if the SCA in this matter was creating some sort of a new test for interpretation of contracts.
Mr. Gairenos, the 2 minutes has expired.
Thank you, Chief Justice. Well, I haven't really gotten to the issues, but I have no doubt that once the justices start asking me questions, we will grapple with those issues. May it please the court.
A question on, and it deals with the jurisdictional point and the approach by the SCA in its interpretation. And this was a point that was covered by Mr. Cockrell. In paragraph 11 of the judgment, the SCA says that the words must be construed objectively. And for that pronunciation, it then relies on Novartis and KPMG. Is that reliance accurate? Was that not rejected in KPMG, that approach to interpretation specifically?
Not in my understanding of the case law, Justice Cheeky. My understanding of the case law is that all of those cases, starting with KPMG and then continuing in Novartis, and then of course in Endumeni, as embraced by this court, was that the starting point always of contractual interpretation is to take the words in their proper context, and that you may not use the context to try and amend or vary or contradict the written word.
What the SCA said was that the words, it says that you must have regard to the words used. And then it says the words must be construed objectively, and that is where it ends. And this is where my question arises.
We would submit, sorry, I misunderstood the question, Justice Cheeky. We would submit, yes, that the SCA was correct in that regard, that one has to have an objective test applied to the words, because we know, of course, that one can never hear evidence of the intent of the parties. And that would introduce a subjective interpretation of the words. Subjective because you're listening to the words of the actual parties to the contract and what their understanding was and what their intention was. And you don't do that. You apply an objective test by looking at the words on the paper in the proper context, of course, of the entire agreement, and of course the background contextual evidence, in order to try and put oneself as closely as possible in the shoes of the parties to the contract, but without hearing evidence of their subjective intention.
So are you then submitting that the intention of the parties in concluding the contract should be ignored?
No, the intention...
And as a sequel, sorry to interrupt you, and as a sequel, did those cases then decide that the intention of the parties when concluding the contract should be ignored altogether?
Thank you, Justice Cheeky. No, not at all. In fact, as I understand the case law, the intention of the parties is, of course, paramount when determining a contract, because it's their intentions which lead to what is the consensus between them, to what is then the contract between them. But all those cases said, however, is that you cannot, however, rely on their evidence during the trial, their express evidence of what their intention was. So you cannot have a party climb into the witness box and say, I intended the contract to mean X, Y, Z. That evidence is inadmissible. So you've got to look at it objectively by looking at the words used by the parties in their proper context, but without evidence, as I understand it, of their actual express intention, and without, so when I say without evidence from the parties' mouths themselves, and of course without evidence of the negotiations that passed between the parties, which culminated in the written agreement. And so it's my submission that when the SCA at footnote 10 referred to those cases, it was in the context of those cases saying exactly that the test is objective in that respect.
Mr. Carinos? I have had a look at the agreement, and I would want you to assist me, especially the clause that you kickstart your argument with, clause 12. And you drew our attention to volume 1 of the particulars of claim, in particular, I think it's paragraph 12, that the closest one can get to ascertaining the case on Delectus Personae on behalf of the applicant, it's the reference in clause 12 of the agreement.
Yes.
And if I read you correctly, one has to read that in conjunction with the agreement itself and look at the words and see whether the words convey what is pleaded in the summons.
Indeed.
If I look at the agreement itself, the closest one can get to in terms of the words that would justify the insertion of clause 12, it's clause 8.1 of the agreement.
Yes, that's what the relied on.
And if I am with you on that point, a simple reading of the words in clause 8.1 of the agreement, can one say they establish a Delectus Personae principle or not?
In our submission, no, they do not. They do not establish Delectus Personae, because on a simple reading of those words, all they establish is the use for which the property may be used by the tenant. It doesn't refer necessarily to a specific tenant and a specific tenant only. In other words, what we're saying is, and I think this question was in fact put to my learned friend by the justices, assuming WAMJ, or any other party for that matter, took cession of the right to beneficial occupation and complied with the provisions of 8.1, could it ever have been said that the nature of the right was Delectus Personae? And we submit not, because as long as that party was complying with the use provisions of clause 8.1, it could never constitute a Delectus Personae. Now, if one takes it then to its logical conclusion, if any party who complies with clause 8.1 is remaining within the parameters of the lease agreement, then there's nothing in the lease agreement, even 8.1 properly interpreted, which is indicative of a Delectus Personae. There's nothing that points to the fact that the right is Delectus Personae to ATS, in other words, to the first respondent and the first respondent only. Now, how the applicant has tried to get around that problem is to suggest that on a proper interpretation of clause 8.1, it imposes a positive obligation. So you will recall they have said that the outcome leads to rather, I think they use the word schizophrenic outcome, because you have a situation where ATS is no longer exercising beneficial occupation, and yet they are positively obliged in terms of clause 8.1 to build educational, religious, and related facilities, and a campus for teaching and so forth and so on. And so how can that be the case if they, and they only, are no longer exercising beneficial occupation? Now, the very short answer to that with respect is that it was never the case of the applicant that clause 8.1 imposed a positive obligation on ATS. In other words, it was never an obligation on ATS that they must build and they must erect this campus. Rather, 8.1 is a right of use. In other words, you may use the property for those purposes and no other purposes. But there was no positive obligation imposed upon ATS or any tenant who's involved in this agreement to build that campus and so forth. There was no positive obligation imposed on ATS to build their theological seminary or the extension of their theological seminary. And why do I say that that is so? One must go back to the pleadings again in volume 1 and go back to the preceding page, which I referred to, and look at page 9, of volume 1. And this is how they pleaded it. This is the case. We were brought to court to meet. This concept of a positive obligation has arisen for the first time in the founding affidavit in these papers. It may have arisen in the SCA. I don't want to mislead this court. I cannot recall. But it certainly was not the case pleaded on the pleadings. And if one turns to paragraph 11.7 on page 9 of volume 1, you see they plead the first defendant had the right. They don't say had the obligation to erect buildings, constructions, facilities, and so forth. They say they had the right. In other words, the parties were at idem during this entire trial that clause 8.1 was about the use. What may ATS use the property for? Not what it is obliged to erect. In other words, yes, if they decide to build something on the property, they must do so in compliance with clause 8.1. But there was no obligation to do so. In other words, and the evidence established anyway, that UJ never, throughout the entire period since 1996 when this agreement was concluded, never suggested to ATS, what's going on, ATS? Why haven't you started building the Theological Seminary? Why have you not built this and built that? They never placed us on terms to do so. And that's because they interpreted clause 8.1 as we have always interpreted 8.1 and as they've pleaded the meaning of 8.1 in paragraph 11.7 of their particulars of claim, and that is that it was a right to make use of the property for that type of usage. Now, if that is so, and that's the case they pleaded, then one cannot rely on clause 8.1 as suggesting that the right is delectus personae to ATS and ATS only. Of course, when one cedes the property to a party who then intends not to use it for the usage set out in clause 8.1, and we know
Mr. Kyrinos, but what's wrong? What's wrong in saying for us to understand 8.1 properly, let us look at context, and context will be provided by this evidence. As a matter of legal principle, is there anything wrong with that?
I would submit not, if that was an issue between the parties in trying to interpret clause 8.1, but the interpretation must be limited to what is the agreed usage. It cannot extend to whether 8.1 means that there's a positive obligation, because that's not the case pleaded by UJ. So insofar as, and we know from the record and so forth, and the pleadings, that there was a dispute on whether clause 8.1 is limited to higher education or any education. But that's a different dispute. That does not inform the process of whether it is delectus personae, because as the justices correctly put to my learned friend earlier, assuming we as ATS had ceded the right to a party who was involved in higher education, could there have ever been a problem? Could there have ever been a suggestion then that the right is delectus personae? So what we are saying is
but the difficulty is we can't get there, because the AD says that evidence that exactly seeks to establish whether in context this is delectus personae. So the AD says, no, you can't get there. So yes, you to then categorically argue that this is or this is not delectus personae, when the antecedent question is the evidence that seeks to establish that in context this is indeed delectus personae. It seems to me that you are arguing in circles, or aren't you?
Well, Justice Malanga, let me just make the position clear with respect, and I have been accused of arguing in circles before, so it won't be the first time. One must concede, of course, that the SCA, if it was allowing evidence, it should have done so merely for the purposes of establishing the nature of the right that we're talking about. Because that is, and of course, whether the concomitant, the opposite side of the same coin is the obligation. The right goes with the obligation. And in order to establish whether that right was delectus personae, you have to have you have to look at the evidence in that regard. But you do not use the evidence of that context for the purpose of interpreting the agreement. That's what we're saying. So it's not a question of the proper interpretation of the agreement. It's a question whether the evidence establishes that the right is delectus personae or not. And in our submission, that's the only way that the SCA judgment can be read. That's what they were grappling with. They were saying to UJ, you came and said, on a proper interpretation of the agreement, it establishes delectus personae. And yet there's no words in the agreement that come anywhere near to establishing delectus personae. So why are we even looking at context? In other words, and perhaps that's where they erred, because you must always look at context to interpret the words. But what they were saying is, but there's no words calling for interpretation.
But then if there were words, they wouldn't, we wouldn't be having this debate at all. We are having this debate exactly because they sought to say, if we look at context, this is the position. Because if the words are there, why does a debate arise at all?
No, the debate would not arise, because if there were words saying, you may not cede, we would be dealing with a pactum de non cedendo and not a delectus personae. I understand that concept. But if there were words, for instance, saying, the parties record that UJ will be prejudiced if ATS cedes the rights, or if ATS no longer has beneficial occupation of the premises, but don't go any further than that. There's no agreement not to cede. They just merely record that UJ will be prejudiced. I suppose then you could say, looking at those words in the proper context, one establishes that the parties intended that the right must be delectus personae. But again, then you're interpreting words in the contract.
And those words about prejudice, you're talking about them being where? Being in the agreement itself?
Yes. In other words, had we in the agreement had a recordal say, I'm just using an example, had the parties recorded that if ATS no longer has beneficial occupation of the premises, then UJ will be prejudiced. Now you're trying to interpret those words and
something quite unlikely.
Oh, sure. That's why I said it's an example.
Will be prejudiced in the agreement itself.
Yes, but I'm saying had
rather
those
unusual.
Words, yes, I understand that, Justice Madlanga. It would be unusual, but I'm saying as an example, if such words had been found in the agreement, one would be justified in saying, well, I must interpret those words in context because I'm interpreting those words. The difficulty the SCA found itself with is that there were no words in the contract calling for interpretation in order to establish delectus personae. And what I was saying earlier, that perhaps the problem arose because of the way and the manner that the pleadings were pleaded in the manner, because that's exactly what the SCA said right at the outset. This is what's been pleaded on a proper interpretation of the lease agreement. The rights are delectus personae.
If there were words, in all probability, it would more be a pactum non delicatendo situation than the delectus personae. Because why can't you establish delectus personae by context? Because you seem to be arguing that you just cannot. Not personae by context.
No, I'm not saying that.
I misunderstand you, or I misunderstand you.
No. I think the point is this. Of course, one can have regard to evidence to establish the requirements for delectus personae. But the problem here became what the court was saying. The court, and perhaps the SCA was wrong in that context, they misunderstood the position possibly that UJ was introducing this evidence as context to interpret the words in the agreement and yet no words were there to be interpreted to establish the lectus personae. And I say that problem arises because of the way it was pleaded. If, however, one says, okay, well, in order to establish the lectus personae, you don't have regard to, you don't even need regard to the agreement other than to establish what is the right. What is the right in this agreement? The right is very clearly the right to beneficial occupation. That's the right that was ceded. Then you go back and you look at the evidence about why would that be more onerous to UJ had the right to beneficial occupation been ceded. And if you then can establish, well, clearly it will be prejudicial to UJ if the right to beneficial occupation is ceded to another party other than ATS, then it's open to you to argue that the right was the lectus personae. But what I'm saying is, with respect, it's not about the intention of the parties as found in the written lease agreement. It's about whether the right is the lectus personae by its very nature. And of course, having regard to the requirements for that.
Because I understand them to be saying, maybe if you look at 8.1 as is, some other institution, my Wits example earlier, is brought in the place of WMJ, and it is to establish a higher education institution with a religious component and everything else.
Yes.
So they are saying, maybe on the face of it, it may not be that apparent that this is the lectus personae, so Wits may on the first face of it come in. We want to lead evidence of context to show that no, Wits may not come in. What is wrong with that?
Well, the problem would be if you're using that evidence to interpret clause 8.1, we would submit, if you're going to lead evidence about the prejudice to UJ and so forth, and why, for example, Wits can't come in, who would apparently would be compliant with clause 8.1, and why clause 8.1, or in fact the entire lease agreement, is limited to ATS and ATS only, you would in fact then be amending or adding words to the contract, because it's not a question of interpretation of the words that are there. You need to add words then to make it so. And that's where the problem arises, because you are effectively using contextual evidence to add words to the agreement which are not there. And remember, we must never forget the purpose of interpretation of the words in their proper context is to ascertain what the parties intended by using those words and not other words.
That response reminds me of something that was said by Justice Wallace, writing extracurrially. The bulls go shucks. So we must not bring in context to say we are not talking about male bovine animals injuring a school of aquatic animals. We must not bring in those words for context.
Yes.
That one would understand your argument, or not?
Perhaps, Justice Madlanga, I can better explain my submissions by reference and showing where the conflation has come and the confusion in the minds of the applicants, potentially even at the time in the minds of the respondents, and potentially in the minds even of the SCA at the time. And I want to refer the court to a judgment which was referred to by my learned friends in the heads of argument. And everybody's happy with what that judgment said in relation to the test for Delectus personae. But neither of us took this court a little bit further. And I want to take the court a little bit further in that judgment, because something happened in that matter, which I say is very analogous to what is going on and the mistake made in this matter. And if you will allow me to take you to the matter of Densam Pty Ltd versus Sywell Nat Pty Ltd 1991-1, volume 100. It's a judgment of the appellate division. It was referred to in my learned friends' heads of argument in the context of setting out the test for Delectus personae. And the discussion in that judgment begins at page 112 And if the court will allow me just quickly to read, to just set out the test again, and then we'll get to the rather interesting part of the judgment, where His Lordship Mr. Justice Botha in that court said, this approach I consider to be contrary to principle and authority. The question whether a claim, that is a right flowing from a contract, is not cedable because the contract involves a delectus personae, falls to be answered with reference not to the nature of the cedent's obligations vis-a-vis the debtor, which remains unaffected by the cession, but to the nature of the debtor's obligation vis-a-vis the cedent, which is the counterpart of the cedent's right, the subject matter of the transfer comprising the cession. Now, that we are all in agreement, that is the test. They go on in the next page to say, when the learned Chief Justice referred to the contract being personal in its character, it is clear in my view that he had in mind the obligation of the debtor, in other words, the other party, in our case, UJ. For it is only in relation to the performance of that obligation that it can make any difference to the debtor, whether it is the cedent or the cessionary who is entitled to enforce the contract. Now, if you go read on further then, at page 113 against the letter H, the SCA, or the appellate division as it then was, it sets out what it put to counsel as being the conflation of issues which led to the problem, and I say it's the same problem in this matter. They say, His Lordship Mr. Justice Botha says at 113 against the letter H, as I've already attempted to show, the notion of the contract being personal in this context cannot be divorced from a consideration of the nature of the obligation resting upon the debtor. The mere fact that the cedent creditor, which in this case is us, ATS, may possess outstanding qualities of forbearance and the like, as opposed to the cessionary, is irrelevant in law, at least in relation to the concept of delectus personae. In this connection, it was suggested to counsel in the course of his argument that he might be confusing the non-cedability of a claim by reason of the nature of the obligation of the debtor with the non-cedability of a claim by reason of a tacit agreement not to cede. In other words, pactum de non cedendo. He then says that counsel jumped on that opportunity and wanted to then rely on the pactum de non cedendo, and the court said this avenue of escape was not open, and it explained because such reliance on a pactum de non cedendo had not been pleaded in the matter, and the other party would have been prejudiced because it would have changed its approach to the matter and potentially led other evidence. Now, my learned friend has made it very, very clear that the pigeonhole they chose is delectus personae. They are not and have never relied on a pactum de non cedendo. They obviously cannot rely on it expressly because it's just not there. And they have not relied on a tacit pactum de non cedendo. And yet, perhaps that is what they should have done. Because when one considers the evidence that was led in order to try and establish that the right in this matter was in fact delectus personae, in the sense that it cast a more onerous obligation on UJ, had it now to deliver that obligation to a different party, they just don't meet the test for delectus personae. Perhaps, and I say this perhaps, we will never know, they might have succeeded or tried to succeed on tacit pactum de non cedendo by leading the evidence that had the officious bystander asked the parties, can this right be ceded? Since you have not said that in your agreement, would the answer probably have been, no, it may not be ceded for X, Y, and Z reasons, irrespective of prejudice to UJ. But once they rely on delectus personae and delectus personae only, they have to meet the requirement of proving prejudice to UJ. And perhaps it might be an appropriate time then for me to move to that and to show, well, the evidence, let's accept for the purpose of argument that the SCA was incorrect in not allowing evidence. In other words, they were correct in not allowing it for the purposes of interpretation of the contract. In other words, you don't allow it in to give context to the words in the agreement because the words do not appear in the agreement. But had they led the evidence to try and establish that the right is delectus personae in its nature, what have they said to this court? Why is the right delectus personae? In other words, why is the obligation on them more onerous if they don't have to render that obligation to ATS and ATS only? So what they have said is this: it would lead to the, I've already dealt with that argument, it would lead to the schizophrenic outcome that ATS is no longer able to comply with clause 8.1. And with the greatest of respect to my learned friends, that schizophrenic outcome is more of a delusion, which is cured by a healthy dose of legal principle and application of the facts of the matter, because we know that the test is not how ATS is going to have to comply with its rights. Then some actually says that the rights, or the obligations rather, the obligations of ATS remain unaffected by the session, because you cede a right, you do not, and you cannot cede obligations. ATS did not purport to try and cede obligations. In fact, the actual session agreement, which is also in volume 1, attached as an annexure, and it's at page 57 of volume 1. If one turns to page 59 of volume 1, you will find a clause headed acceptance of lease obligations. And in that clause, because we have not ceded the obligations, and UJ can always look to ATS to comply with its obligations, ATS in turn had to enter into an agreement with WAMJ to say, I have to still comply with my obligations to UJ. Therefore, you, WAMJ, must agree to comply with my obligations also. In other words, you may not do something which the lease agreement does not allow you to do. And I as ATS can look to you and enforce that you comply with the obligations as set out in the lease agreement. So what does this mean? This merely means that if there is an obligation on ATS to UJ, it must still be complied with, and UJ can compel such compliance still against ATS. So there can't be prejudice in that regard. And there's no schizophrenic outcome.
Mr. Kairionis, I'm sorry to interrupt you. This thing bothers me. We had a debate on the approach of the SCA, and then I decided to look carefully in Novartis. And in fact, it touches on what you are talking about, and also the cooperation agreement.
Yes.
In our earlier debate, I understood you, and maybe I misunderstood you, to be saying that what the parties meant to achieve is irrelevant in interpretation. Is that what you were saying?
No.
Was
no,
that your submission?
No. What I submitted, Justice Cheeky, is that what the parties intended is paramount in interpreting a contract. That's where you find the intention, but you must find that intention in the contract in its proper context, not through direct evidence from the parties of their intention.
Okay, now I understand you then, because I thought that you were in a disagreement with me.
No, not at all.
Now, okay. Now, this cooperation agreement, it worries me. I know that you said that the cooperation agreement, no weight should be put by this court or placed by this court on the cooperation agreement because it was cancelled, number one. Number two, because you said that two of the witnesses of the applicant had said that they did not consider it. I've noted your submissions in that respect. If we are not with you on those two submissions, is it a document if that would be relevant in actually interpreting the lease agreement?
My submission is it would not be relevant towards interpreting the lease agreement. It may, if it evidenced anywhere in that cooperation agreement, some sort of prejudice to UJ, if ATS ceded the right, it may have been relevant towards establishing prejudice to UJ. In other words, establishing that the right is Delecta's personae. But I can assure you, with respect, there is nothing in that cooperation agreement that shows that UJ would in any way be prejudiced if the right was ceded to a third party, as long as that third party complied with the provisions of clause 8.1, properly interpreted, in other words. Now,
but does it not show that the whole purpose of the agreement was that there should be symbiosis between the two organizations? And I referred earlier to chapter 2, which actually maps out the teaching programs between the two organizations. And for me, chapter 2 then suggested that, in fact, what the parties wanted to achieve or intended to achieve was exactly what is mapped out in the cooperation agreement.
Thank you, Justice Chiki. If I may answer that. Well, the cooperation agreement certainly mapped out symbiosis, and we get it even from the name of the agreement. It's called the cooperation agreement. There was no doubt that these two parties were going to cooperate, but cooperate for what? Cooperate for academic purposes, not for the purposes of leasing land to each other. There's in fact no reference in that agreement to the leasing of land in the future or anything like that. So you find the symbiosis already in the cooperation agreement. And the only reason that the cooperation agreement was referred to, we say, was to get our foot into the door with UJ. As my learned friend correctly pointed out, we did not fill in a request or an application, so to speak. There was no advertisement in the paper that we answered to in order to lease these premises. We had to get our foot into the door. So what clearly Mr. Kuipers did in his letter was try to sweeten UJ and refer UJ and say to them basically, look, UJ, you and I are friends. We are working together in terms of the cooperation agreement. Won't you be nice to me? I need property. I don't need the property only and solely for the purposes of the cooperation agreement, because you will see, and it was conceded, I think by Professor O'Brien at least, that the Kuipers letter referred to all kinds of other things which ATS was doing and diploma courses that they were giving and all kinds of other things that had nothing to do with UJ and had nothing to do necessarily with higher education per se. But they found themselves expanding. No doubt part of that expansion was also as a result of the cooperation agreement, and they needed more space because their existing campus was right next door to this property of UJ, the property we're talking about. So it made sense. I need more space. Where should I look to for more space? There's an open piece of ground right next door to me. Who does it belong to? It belongs to UJ. Hang on a second, UJ is my friend because of this cooperation agreement. Let me write to them and remind them that they are my friend, that we are working together, and it would therefore make sense to be amenable to lease me the property. And let's not forget, originally it was for the purpose in that letter of purchasing the property. It was only converted to a long-term lease when they were told that the minister would probably not be amenable to an outright sale, but only to a long-term lease. Then they started talking about a long-term lease. The cooperation agreement, the witnesses testified, played no further role in the negotiations. Once it got them in the door, they then dealt with each other commercially at arm's length as two commercial contracting parties. They went and got all kinds of quotes on the value of the property by experts and so forth to work out a commercial correct price for the property. When it was turned into a lease, they then said, well, that price will become a once-off lease payment. Now, I want to point out, however, if one is considering the cooperation agreement and whether that in any way informs the debate as to whether the right was Delecta's persona or not, we must not forget we have here a 30-year lease with an option in perpetuity of extending it for further periods of 30 years as long as you comply with the requirements of the lease. And yet the cooperation agreement can be cancelled on 1 year's notice. So how does one marry those two things together? UJ can win. Sorry?
I'm sorry to interrupt you, Mr. Karinas. While we are on the cooperation agreement, the applicant's case is that if the purpose of the lease agreement was to give effect to the cooperation agreement, then the respondent's rights are delictus persona. Now, the respondent admits, this is in its plea at page 104 of the record, that in February 2010, and this is 2 years after the cooperation agreement terminated, that UJ offered the respondent an amount of 2.5 million rand, as well as a portion of the leased premises in exchange for cancellation of the lease agreement. Doesn't that go some way to suggesting that, that since the cooperation agreement was terminated, the applicant no longer had an interest in leasing the property to the respondent? And perhaps even goes further to show that the lease agreement was umbilically linked to the cooperation agreement.
Well, what they certainly never did and never relied on is the cases in cash converters and so forth to say that the two agreements are so intertwined that the death of one obviously means the death of the other. That was never the case, and that was never the evidence. And that's why we say the lease agreement was not to give effect to the cooperation agreement. The cooperation agreement could still have continued even if UJ had never agreed to a lease agreement. They would still have continued offering the services in the cooperation agreement to UJ, irrespective of a lease agreement. Remember, when the cooperation agreement was concluded, the lease agreement was not even on the table. Nobody had even considered a lease agreement at that stage. Yet, and they had their existing campus. And so one must assume from their existing campus, they were going to then provide the services. They then felt they needed more space because they were expanding as a business. So they then said, well, as I said earlier, there's a property next door. Let's go speak to UJ. Let's make UJ positive towards us by pointing out that we are in an academic cooperation agreement together. So it makes sense to agree to give us a lease or to purchase these premises, but they were not linked together in any way. And so therefore the mere fact that the cooperation agreement could be cancelled on 1 year's notice, it could have been cancelled already in the mid-90s. It could have been cancelled even before the lease agreement. It could certainly and was cancelled after the lease agreement was concluded, but that had no effect. And the applicants did not rely on that to try and show that the lease agreement was no more. Now, if that's the case, why should the cooperation agreement in any way inform this court or any other court as to whether the right was delectus persona or not? It doesn't show any prejudice.
Let's leave aside for a moment whether the right was delectus persona or not. Both parties had in mind that the respondent would use the leased property to develop a theological college. The respondent didn't do that. The respondent paid a once-off amount of 700,000 to UJ for the 30-year lease. After that, the respondent sold its rights under the lease for 6.5 million rand. What do you say about the equities of the matter?
Well, it's difficult to say much about the equities since we didn't really hear evidence as to what the equities were. I can just point out this, and I must say you have caught me a little off guard with that question, but let me try and answer it as best as I can. You're comparing 700,000 Rand in 1996 to 6.5 million in 2011. So obviously, I'm not sure what 700,000 Rand would be worth in 2011. I'm certainly not sure what the value of the property was in 2011 because we didn't have such evidence. So I'm not sure, and I cannot make a submission to you whether it was equitable or inequitable, because for all we know, and especially having regard to evidence we've seen in the founding affidavit and even in our answering affidavit in this application, that the property is now much sought after by developers for the purposes of student accommodation. That seems to be a big business these days, student accommodation. There's a critical shortage of that. So for all we know, as we sit here, that property, the value of occupying that property and building in accordance with clause 8.1, which includes accommodation, may very well be 6.5 million. So the equities may be neither here nor there, in fact. We don't know that.
Let's just take it one step further, Mr. Karinos. This is a public university, and that is publicly owned land. Does that not come into the question of whether the university has been prejudiced by the session?
Well, Justice Theron, I don't recall that there was any evidence in that regard put up by UJ about what prejudice they had. I'm talking about during the trial. They tried now in their founding papers to set out and make out a case for this prejudice that they're suffering now because they can't exploit this property for the purposes of students and so forth. And we actually took the point in our answering affidavit, you cannot now, in the application for leave to appeal before this court, try to make out the case which you should have made out before the court at quo, because we would have had the opportunity of dealing with that evidence. And I'm not even sure, to be quite honest, Justice Theron, whether that case was ever even pleaded by them as part of their prejudice.
And my last question on this train, Mr. Karinos, this is publicly owned land that was expropriated and then given to a public university. Would that be relevant in terms of context?
Again, it was not the evidence led, as far as I can recall, at the trial. This was evidence that was put up in the founding papers. I don't recall, and I must say when one hits 50, your memory seems to get a little bit dodgy, but I can't recall that there was that evidence during the trial. And certainly there was no reliance on that fact by UJ during the trial. So with respect, it is perhaps a valid question, but it's a little bit of an unfair question at this juncture in the proceedings where we're now dealing with a leave to appeal before this court, because that's not an issue that was dealt with during the trial. And of course, the respondents were not then afforded the opportunity of dealing with that. I, for the first time, really saw this allegation made about the expropriation of public land and it being given to Rao, as it then was in the founding application in this application before this court now. And I'm sure that's where you can make out your case with respect.
Can I take you back to the question about prejudice? When one determines whether a right is personal in nature or not, does one not consider whether there would be prejudice to the debtor?
Yes, that is the test.
Yes. So even if there was no evidence on it, it is a test. It is a legal test. So one would have to look at that legal point.
Well, I think my learned friend, if I recall, it answered a similar question by saying it's a question of law and of fact. If you are going to try and establish the lectus persona, we would submit you then must plead and prove the prejudice to the debtor. Now, I don't recall there being specific evidence by anybody as to why UJ would be prejudiced if this right was ceded to another party. There was a lot of focus on this issue of, well, and that was more in legal argument. There was a lot of focus, if the right is ceded by ATS to another, and ATS cannot comply with the positive obligation placed on it in clause 8.1, and that was their case as pleaded, you have made yourself incapable of complying with your obligation in clause 8.1, or of the right to in 8.1. We call it a right, they also called it a right. So therefore, because you are incapable of doing what clause 8.1 says you must do, which is build a college and so forth and so on, you have therefore prejudiced us because we can't enforce that. And that's what I was trying to establish earlier. Of course, they can still enforce it. Their obligation remained unaltered. Now they say, yes, but I must enforce it against ATS. And ATS can't comply because they're not in beneficial occupation. But don't forget that the session agreement provides that ATS in turn can force WAMJ or whichever other party it ceded the right to comply with the provisions of the lease. So the right of UJ remains unaffected by the session. And if that is so, how could it ever be delectus personae? Which is why I said earlier, perhaps they they pinned their colors to the wrong ship.
Mr. Karinos, how does one practically compel ATS to comply with its obligations to build a higher education that was 8.1 if WMJ is going to build a primary education institution?
Because the lease also provides that UJ has to consent to any plans and building before anything commences. And that's how you get them to comply. You look at the plans, as they did in this matter. You look at the plans, you see, but these guys are intending to build a primary school. That's not what we believe clause 8.1 provides for, and you decline to approve those plans. And that may lead then to a different dispute. And that may lead to a dispute as to should they or should they not have declined, and it'll lead to a dispute about the proper interpretation of clause 8.1 and whether it refers to higher education, which by the way it doesn't, it just refers to education, but on a proper interpretation, was it intended to mean higher education or not? But that's a different dispute. That doesn't inform the issue of whether it was intended to be delectus personae. And sorry, I use the word intended to be incorrectly, because it's not about the intention of the parties. It's whether the right per se is delectus personae or not.
Can I just, okay.
Mr. Karinos, I put a question to Mr. Cockrell earlier. I'm interested in your response that if the case had been run on the breach of 8.1, would they be home and dry? The response that I got from him was that they would be home and dry on the basis of any breach of 8.1. I'm interested to hear what is your retort to that.
My retort is very simply that Mr. Cockrell, with respect to him, got that wrong, because the answer must be no, because if the case was predicated not on a repudiation, but on a breach of clause 8.1, the lease agreement provides that they have to send me written demand to rectify the breach before they are entitled to cancel. It's common cause in this matter, there was no written demand to rectify any breach. In other words, to place us in mora or to place us in a position to remedy the breach. Their case was that this breach was incapable of being remedied and amounted to a repudiation of the agreement. And we say that's not correct. If it was a breach at all, well, can I just interrupt myself, Justice Matopa, to say one would never have gotten to the position of breach because you apply to start building. You put plans up to them which they have to approve. They decline to approve them. If you then decide, okay, well, they're right, because we're not building a facility for higher education, well, that's the end of that. There is no breach. You're not breaching because you're asking them to approve something they don't want to approve or they're not obliged to approve. But you're only breaching if you then decide to, irrespective of their declining the plans, decide to start building anyway. And then you can send a breach letter and say, listen, we declined your plans. We see that you're trying to start to build. Stop doing that. within so many days, failing which we will cancel the agreement. But that's not what happened in this matter. They relied on this matter on a repudiation of the lease agreement. Because as we know, when it comes to repudiation of a lease agreement, you don't have to send a breach letter. You can just accept the repudiation and cancel the agreement, which is what they purported to do.
But if notionally a party conducts itself in circumstances where it evinces a clear and unequivocal intention of no longer to be bound by the agreement, and then what would what would an officious bystander say when looking at those set of facts to say that conduct to me amounts to a breach of the agreement? Would that not be the test?
Well, the test, as you correctly point out, is an objective test. One must look at the conduct and say objectively whether from that one can, does that evidence an intention not to be bound by the agreement. But one must be very careful not to take conduct which evidences a breach of the agreement and to say that at the same time evidences an intention not to be bound by the agreement. So you can breach an agreement and not be guilty of repudiation, but then you must be placed in mora to rectify the breach. Or the conduct.
Well, let's look at the facts here. In 8.1 of the agreement, it made, there are certain stipulations, I would rather say requirements, that ATS had to do to bring itself within the confines of the agreement. And what ATS does now is it concludes a session on terms entirely different to the main agreement that it had with the UJ. If one looks at those facts objectively, should one still say that there's still an intention on the part of ATS to consider itself bound to the agreement it had with UJ?
We submit most definitely, Justice Matopo, because in fact, everything that ATS did was in trying to comply with the agreement. The first point, we must just be careful about saying that clause 8.1 imposed a positive obligation on ATS to in fact build what's set out in clause 8.1. As I pointed out earlier, clause 8.1 is about what it may do, the right it has to build there. It doesn't have to do that. It may, as it is now, leave the property vacant if it wanted to do. So that's the first thing. And what we say, once there's no positive obligation to in fact build, if you're going to build, you have to comply with 8.1. You may only build what 8.1 envisages, but you don't have to build. There's no positive obligation. That being so, by then ceding, that does not mean that you have repudiated or that you that it's delectus personae. In other words, without it being delectus personae, the mere fact of cession doesn't constitute a repudiation. So the repudiation is tied up with a finding of delectus personae. If there's no delectus personae, there's no repudiation by the mere fact of cession. What do the parties then do after the cession agreement has been concluded? They agree between themselves in the session that they will comply with the provisions of the lease agreement. And they then write to UJ to ask for the permission which the lease agreement obliges them to do, to build what they want to do. Now, the problem arises, of course, that WAMJ and UJ and ATS believe that clause 8.1 properly interpreted does not limit them to higher education, because it doesn't say that in the wording. And of course, UJ believes it does limit them to higher education. And that may be a dispute on its own, but that does not lead to the finding that the right is delectus personae. You have to first make that finding and then look at the conduct and find whether there's a repudiation or not. That's why I say, without delectus personae, there's no repudiation. The conduct of ATS does not evidence an unequivocal intention not to be bound by the agreement. The only way you can get there is to first find that the right was Delectus personae. And I've already made submissions on why it is not Delectus personae, because it does not prejudice the obligations imposed upon UJ. They remain unaffected. Those obligations were to provide beneficial occupation. Well, that hasn't changed. It hasn't been made any more onerous in any way whatsoever, which is why I said earlier, perhaps the better route for UJ would have been to try and prove a tacit pactum de non sedendo based on the surrounding circumstances. But that's not the case they pleaded, and that's not the case they proved. And in fact, we even heard Mr. Cockrell today telling this court, that's not the case they're pursuing. It was not the case that ATS had to meet. I believe, Chief Justice, that from the questions posed to me by the various justices, I believe I've canvassed everything in my notes. If I can just have a minute to just check, and then also just see if there's any instructions from my remote attorney. If I may just take a minute, Chief Justice.
Go ahead, Mr. Kairenos.
Thank you, Chief Justice. Yes, sorry. Thank you, Chief Justice. I just wanted to add, we dealt with the cooperation agreement and why that did not establish Delectus personae. There's also the other issues they relied upon was the wording of the application to the minister and the minister's consent. But we of course see that the minister's consent does not limit the consent to ATS and ATS only. They say, well, you can imply that by looking at the application to the minister, which did refer to ATS. But the minister gave a blanket consent. In respect of some of the other properties, he wasn't even aware who the intended tenant is going to be, and yet was still happy to give a blanket consent. Basically, he was happy to rely on UJ to do what they wanted to do and put whatever tenant they wanted to put into those properties. The only reason that ATS was specifically referred to in the application was because they knew about ATS's application to them for leased property. So
I must just say that I'm not saying that you should revisit it. I'm not with you when you say that the minister was not aware that ATS was involved in this, because the letter specifically mentions ATS. And the minister must have considered the application and knew that ATS was involved. So when you say that the minister didn't even know that ATS was the intended lessee, I don't get that point. But I'm not asking you to address it. You've addressed it in your letter.
There may be a misunderstanding with respect. I didn't say the minister was not aware of ATS. He certainly was. What I'm saying, the minister was not aware of the prospective tenants of all the other properties, because the letter to the minister sought also consent from the minister in respect of other properties for other tenants. The other tenants were not even mentioned. They were not identified. And yet the minister gave a blanket consent to the lease of all the properties. The point I'm merely making is it does not appear that the identity of the tenant was material to the minister. Otherwise, he would have asked in respect to the other properties, hang on a second, you've identified ATS, who are the prospective tenants for the other properties? But it doesn't appear that the identity was material to the minister at all. And that's the point I wanted to make. But in conclusion on this point, even the reliance on those factors, the application to the minister's consent, and so forth and so on, do not show any prejudice to UJ if the right was then ceded to another tenant, as long as it complied with the usage compliance of clause 8.1. So in summary, we really say that the mistake UJ made in this matter was to pin its colors to the mast of Delecta's Personae. But with respect, that ship doesn't float. They could not prove a Delecta's Personae. They did not board the ship of a tacit pactum de non sedendo, so they can't rely on that either. And if that's the case, there can be no finding. And the court was, the SCA was correct to find that there was no Delecta's Personae in this matter. Ultimately, it may even be a situation, and I'm just putting it out there, that the Supreme Court of Appeal may have come to the right conclusion, possibly even for the wrong reasons, by excluding the contextual evidence. But that then does not allow UJ to appeal the matter, because one doesn't appeal the reasons, one appeals the ultimate finding of the court. And so if this court were also to find that the right is not Delecta's Personae, well, then that's the end of the appeal anyway, irrespective of whether this court disagrees with the reasoning of the SCA for coming to that conclusion. In summation, then, of course, we still say that this court should not grant leave to appeal, because this does not raise a constitutional issue, does not raise an issue of public importance. There is no inconsistency in the SCA's embracing of endumeni. There may have been an erroneous application of the principles of endumeni to the facts of this particular matter, as I said earlier, probably because of the way the matter was pleaded, but that still would not, with respect, and should not allow this court to then exercise its appellate jurisdiction over the finding of the SCA. And ultimately, for the reasons I've just proposed, it appears that the finding of the SCA, the ultimate finding, is in any event correct, albeit possibly for incorrect reasons. And in those circumstances, I would submit that the application for leave to appeal be dismissed with costs. Alternatively, if this court does grant leave to appeal, that the appeal should be dismissed with costs. Thank you, Chief Justice.
Thank you, Mr. Kairenos. Mr. Cockrell.
Thank you. Thank you, Chief Justice. I'm going to be brief. Let me take the submissions in the sequence in which my learned friend made them. Let me start with his submission regarding the SCA judgment in Novartis. You'll recall that's one of the judgments cited in footnote 10 of the judgment. And my learned friend made the submission that the Novartis judgment supports what is stated in the text of paragraph 11 of the SCA judgment. With respect to my learned friend, that's just blatantly wrong. If one reads the Novartis judgment and we extract a long portion in our heads, what Madam Justice Lewis did in Novartis is to engage with the very submission that when you interpret words of a contract objectively, you don't have regard to background and context. And that's the very submission she rejected in Novartis. So, and as much as the SCA, as much as my learned friend relies on Novartis as support for the objective theory divorced from background and context, that's just wrong. My learned friend then said that the case we've now mounted regarding a breach of the positive obligation in 8.1 of the lease is not the pleaded case. Again, with respect, that's wrong. And I'm going to ask the court to go to our particulars of claim in volume 1, page 13, paragraph 23.1. where this is the pleaded case, 23.1, regarding the repudiation. The first defendant demonstrates an unequivocal intention not to be bound by the lease agreement and repudiate the lease agreement by, sub 1, purporting to cede the rights it derived from the lease agreement to the second defendant, that's WAMJ, thereby purporting to divest itself of the ability to give effect to the agreed use of the lease premises. That only makes sense if 8.1 of the lease is read as imposing a positive obligation. That was the whole point. ATS, when it gets rid of beneficial occupation, can no longer comply with 8.1. That was the pleaded case. The learned friend then said that the evidence of context is irrelevant because the contract is silent regarding Delecta's Personae. Chief Justice, members of the court, off the top of my head, I can't recall any contract which talks expressly to Delecta's Personae. One can think of many contracts that contain a pactum de non cadendo, but contracts don't talk to Delecta's Personae. And that's the whole point of the interpretive exercise, is to interpret the contract and ask yourself whether it creates obligations on the part of the debtor that are so personal that the creditor can't see them. So with respect, it's of no help for my learned friend to say the contract is irrelevant because the contract is silent. The contract will almost always be silent regarding Delecta's persona. My learned friend then made some criticisms of the way in which we pleaded the case and said, well, perhaps the evidence regarding background and context may have been relevant had we pleaded the case differently. But with respect to my learned friend, he was in the trial, I wasn't in the trial, but I have read the transcript, and nowhere did he object to the evidence. To be fair, there's one interchange with Her Ladyship Madam Justice Victor, where my learned friend quite correctly says that lay witnesses can't give evidence regarding what the contract means. He places that on record, and I record that. But at no stage did he object to the evidence that was led by UJ's witnesses. And the evidence was about background and context. So in as much as the complaint is that the case advanced is not the pleaded case, well, if that were correct, he ought to have objected to the evidence, and he never did so. My learned friend then relied on the Densham judgment at page 113H. Chief Justice, I've read that passage. It's of no relevance whatsoever. We have all along acknowledged the distinction between Delecta's persona and a pactum de non cadendo. The pleaded case was not a pactum de non cadendo, so with respect, Densham takes it no further. May I then deal with the point of substance? And it went through a number of submissions of my learned friend. We had referred to in our heads to the fact that the session created a schizophrenic outcome where the obligations and the rights are disconnected. And I wrote down my learned friend's submission. He said that we are delusional because there's no schizophrenia. But with respect to my learned friend who simply doesn't grasp the point or doesn't engage with the point, and let me make the point as crisply as I can. The effect of the session is for ATS to say that I will no longer have beneficial occupation. WAMJ will have beneficial occupation. If we are right that the obligation in 8.1 is a positive obligation to build a campus for tertiary education, then WAMJ cannot comply with that obligation because it's not in the game of providing tertiary education, and ATS can't comply with the obligation because it doesn't have beneficial occupation. So with respect, the disconnect is there and the disconnect is patent. There is one interesting feature of the session agreement that my learned friend took you to that I'm going to ask you to go to because he didn't have regard to it. If I could ask you to go, still relevant to the schizophrenia point, to page 59 in volume 1, which is the session. So my learned friend took the court to the session agreement, and he pointed out quite correctly that the session transfers rights, it doesn't transfer obligations. And of course that's correct because an obligation can't be transferred without the consent of the debtor. But the schizophrenia, the disconnect, arises for the reason I've just made. And if you'll go to clause 4.3, you'll see that the cedent, ATS, was well aware of the problem. This is what 4.3 on page 59 says. The cessionary, that's WAMJ, acknowledges that should it fail to comply with the lease obligations or any other obligation, such failure may result in the cancellation of the lease according to its terms, in which event the cessionary, WAMJ, shall have no claim against ATS, and we can skip out the rest. And then the last sentence, the cessionary, that's WAMJ, shall not for any purpose be entitled to allege or claim that the obligation to comply with the lease obligations remained with ATS. So as a matter of law, the obligation stays in ATS, but the parties, WAMJ and ATS, expressly provide that as between them, it will not be permissible for WAMJ to say that the obligation remained with ATS. And what that means is ATS is washing its hands of complying with the lease obligations. It has no intention of doing so. Otherwise, 4.3 would make no sense. My learned friend was asked some questions about the relevance of the cooperation agreement. He said it was just a way of getting a foot in the door. With respect, I referred the court to the letter this morning, but my learned friend skirted around it. Let me ask you to go to that letter because it's a complete answer to what he said. It's volume 6, page 539 of the record. Volume 6, page 539. Remember, the submission of my learned friend is that the cooperation agreement was a foot in the door. It did not impact on the conclusion of the lease agreement. Well, here's what his own client says, page 539. I'm going to translate it. It's the second unnumbered paragraph, dit word bevestig. It is confirmed that it's the great concern of ATS to construct synergy with RAO and to improve the synergy so that the two institutions can support each other. Ons is dit eens met u. We are in agreement with you that die ooreenkoms, that's the cooperation agreement, wat tussen ons twee inrigtings bestaan, die grondslag is vir die onderhandelings vir aankoop van bogenoemde grond is. So at the time, what was contemplated was a sale. It later became a lease. So his own client acknowledges that the cooperation agreement is the grondslag, is the basis for the negotiations that they then enter into. So the suggestion that my learned friend, that you can then scissor out their cooperation agreement, it has no further work to play when the parties conclude the lease agreement, is inconsistent with the letters from his own client. Justice Theron asked my learned friend, what about the equities? And my learned friend said, well, he didn't have the numbers to hand and it wasn't part of the evidence. But with respect, Justice Theron, the point you raise is, if I can use this phrase, is right on the money. One of the principles of delectus personae means that the debtor gives rights to a certain person and does not want that person to pass on the rights. Well, one of the reasons for that is that UJ never contemplated that ATS would profiteer from this lease. In other words, it never contemplated that UTS would pay 700,000 Rand in old money and then sell the rights for 6.5 million Rand in new money. I haven't done the sums to provide for inflation, but the whole point about delectus personae is to stop the other party profiteering in that way. That may well be not the case in an ordinary commercial contract, but this was not an ordinary commercial contract. It was UJ coupling its wagon to ATS, never contemplating that ATS would be able to profiteer by selling those rights. The learned friend was asked by Justice Matopo, do we win if clause 8.1 is breached? I had said yes. My learned friend says I'm wrong. I'm going to ask you please again to go to paragraph 23.1 of our particulars of claim because I stand by my submission. My client's pleaded case, volume 1, paragraph 23.1, which you'll find on page 13. I've taken you to it already, but it's so important, let me read it again. The first defendant, ATS, demonstrated an unequivocal intention not to be bound by the lease agreement and repudiate the lease agreement by purporting to cede the rights it derived from the lease agreement to the second defendant, thereby purporting to divest itself of the ability to give effect to the agreed use of the lease premises. So if we write that 8.1 imposed a positive obligation on ATS, and if ATS can no longer comply with that positive obligation because it's no longer having occupation of the property, then with respect, the case is good and my client should win. My learned friend said, well, even in that world, we can only win if we're also right on delectus personae. But with respect, that isn't right. Delectus personae is pleaded in the next paragraph, 23.2, purporting to cede the rights it derived from the lease agreement in circumstances in which those rights were personal to the first defendant and incapable of being ceded. We stand by that, but even if we don't come home on 23.2, we could still come home on 23.1. The only difference would be the session would then be effective rather than ineffective, which is what we say. If the session were ineffective, the rights were never transferred. If the session was effective, the rights were transferred, but ATS has still disabled itself from performing its obligations, and that cause of action would still be good. The learned friend then said, well, what about the minister's consent? It takes it no further because the minister gave a blanket consent. Chief Justice, members of the court, you'll recall, my client, Rao in those days, applies to the minister. In relation to student accommodation, retail outlets, doesn't identify the tenant. In the case of the Theological College, does identify the tenant. Says we need to lend a helping hand to ATS. So even if my learned friend were right about the shopping premises and the student residences, he's not right about ATS because they were picked out, they were referred to. And if nothing else, it supports the Delecta's personae point. In the case of the other premises, my client doesn't identify the tenants. In the case of the Theological College, expressly picks out the tenant and tells the minister, this is who it's for, I need to give them a helping hand. So Chief Justice, members of the court, for all of those reasons, with respect, on Delecta's personae, I'm going to repeat what I said this morning. It's hard to think of a clearer case of Delecta's personae than this. Delecta's personae is when the debtor enters into a contract, gives rights to someone else, and it matters to the debtor if the rights inhere in that creditor or in someone else. Did it matter to you, Jay, if the rights inhere in ATS or someone else? Well, the whole narrative tells you that. They couple together, they're brought together by the cooperation agreement. They negotiate. My client applies to the minister and mentions ATS. They are jointly providing a degree. It mattered to you, Jay, who the creditor was. That is Delecta's personae. And finally, on the application for leave to appeal, if I don't get my foot in the door, then this court will either form the view or will be of the view that the SCA was wrong, but will nevertheless say it doesn't engage my jurisdiction. Well, 1673B says this court may decide any other matter, non-constitutional matter, if it grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance. I'm going to summarize my submission. What do I say is the arguable point of law of general public importance? Well, the first one is, what is the rule that applies to the admissibility of background and context evidence? Listening to my learned friend this afternoon, it occurred to me, it's possible, I put it no higher than that the SCA has misread Endomeni. It's possible that the SCA thinks Endomeni excludes that evidence. I don't say that's the SCA's view. I have no idea in this case, but we shouldn't have to have that debate. We shouldn't have to try and hold up this judgment to the light as we have today and try to work out what the SCA was thinking. The rules regarding admissibility are of tremendous importance for all lower courts, and they would welcome a judgment from this court dealing with the admissibility of background and contextual evidence. It's correct this court has endorsed Endomeni, but if this court were to go further and set out the relevant principles, that would be a point of general public importance that would be of assistance to all the courts. But even if I'm wrong on the Endomeni point, with respect, the submission regarding Delecta's personae still applies. If this judgment is allowed to stand, that is the end of the doctrine of Delecta's personae. It will never succeed. It can never succeed because contracts rarely talk to Delecta's personae. And this judgment says evidence is never admissible because the contract is silent. Well, once that's the case, you can cut that out of all the textbooks on contract law. Delecta's personae is now dead. That, in our respectful submission, is a general point of law is an arguable point of law of general public importance, which ought to be considered by this court. And we would therefore ask you to assume jurisdiction. For all of those reasons, we continue to ask that leave to appeal be granted. And if leave to appeal is granted, we continue to ask that the appeal succeeds with costs. Chief Justice, I think I'm just within my time limit and I'm grateful to you. Thank you.
Thank you, Mr. Cockrell. Judgment is reserved and the court adjourns.
May it please the court.
May it please the court.